this meeting to order. Let's go ahead and go through the roll call to see who's here. I'm here, Drew Lanza. Andrew, you here?
Here.
Anita, are you here?
I'm here.
Eshfar, you're here? You might be on mute. Eshfar, are you here?
I'm here.
Great. Dick, are you here?
Yes.
Franco, are you here?
Here.
Dave, you're here? And, oh, there he is. Here we go. Almost there. I don't know. God, it's taking like a minute. Okay. Howard, can you hear us yet? Howard? Going once. Going twice. Note for the record, our ninth trustee is a vacancy left behind by Vincent Zeri. Gosh, I don't know why he's having such trouble. Connecting, let me go through. Orders of the day. Let's note that we have these felony forfeiture hearings. I see we've got the attorney Mazit May online. So we'll be taking those at times certain 8:30 and 10, well, as soon as the meeting is called to order. Howard, are you online yet? God, that's so weird. It's still connecting. This front side of the meeting will be a little more formal than normal, but in general, once we're through that, our Zoom etiquette.
Hi, Drew. Sorry, I'm here.
Oh, great. So we've got a full complement with one vacancy. We generally let people interrupt the speakers to ask temporal questions, but in the beginning of the meeting, it's a bit more formal. So let's let Councilor Chin Neaton May go at the beginning, and we'll get to that in just a minute. Let me keep going. There is nothing that we have to wave sunshine on. And you recall that at the last meeting, we decided, maybe it was our agenda setting meeting, to put public comments at the beginning of the meeting. So Harvey wrote something over, maybe it was you, Maytex, or maybe it was staff. So at this time, members of the public may comment on items not included on the agenda, provided the matter is within the subject matter jurisdiction of the board. Members of the public who wish to provide comment this time may do so by raising their hand in the Zoom app. Or if you're joining by telephone, press *9 on your telephone keypad. And then when addressing the board, it's *6 to unmute. We'll ask you to state your name for the record, and I think we'll give about 3 minutes. So do we have any members of the public who would like to weigh in now? Any hands up that you see, Linda?
I see none.
Okay, that's great. So I think we are past that. So we're going to go directly now to item. Hang on, I'm shuffling my pages.
Chair Lanza?
Yeah, go ahead. Yes, Maytek, what's up?
So I just received a call from Council Denise Eaton May. She's having difficulties logging in. She was initially logged in, but was logged out. So I'm looking at the gallery. I do not see her currently in the gallery.
Okay, well, look, thanks, Maytek. Will you keep your eyes out for her and just interrupt me when she's back on?
Sure.
Great. So then let's go ahead and we'll just keep plowing on. So our first item of business is the consent calendar. Does anybody want to pull anything off the consent calendar? If not,
I do not, but I'll make a motion to accept.
Great. Dick, a motion from Santos, so I have a second.
Second by Gardner.
Great. Motion by Santos, second by Gardner. Let's go around the table. Andrew, how do you vote?
Aye.
Sunita.
Aye.
Howard.
Yes.
Eshvar.
Aye.
Dick.
Yes.
Franco.
Aye.
Dave.
Aye.
And this is Lanza. I vote aye as well. I'm guessing Peru's not on. Is he, Roberto?
I'm sorry, say that again.
Here.
Oh, you are. Peru
Yes.
is it? Would it be? Can you go now, Peru? I know you probably weren't planning to talk till like almost noon.
No,
Could you?
I'm ready.
Oh, go ahead. Then go ahead. Let's do the oral update. Item 2A from Pramod. Go ahead,
Okay,
just
right.
jump in whenever you see her, Maytak.
All right, thank you, Mr. Chairman. So I'm going to keep it brief. I know we have a long agenda today and other more pressing matters, but you've all noticed the market is falling. There was a violent rally yesterday, up 3.5%. It's down. Nasdaq's down 4% today. S&P down 3% and change. Extremely volatile conditions in the market. As a result of which, fiscal year to date, estimate from Makita as of Tuesday's close, the pension plan was down 1.44%. Fiscal year to date, of course, these are estimates, and these are also not as of month end, something to keep in mind. And the healthcare trust was down 5.5% fiscal year to date. So just, I mean, we have a very investment savvy board, but as a reminder to everyone, this is the nature of financial markets. Markets go up, markets go down. We were up 25% and change last fiscal year. This fiscal year to date, we're down 1.5%, and that shouldn't be a surprise to anyone. I don't think the market is in an oversold condition yet. We may get there very, very soon if we have a few more down days like that. And I've already started talking both internally with my team as well as externally with some managers. If I feel that we need to, re-risk the portfolio at some point, I will bring that to the board. Now, with that, there is one other item on the agenda. That's the pacing plan. I'm happy to take any questions from the board. If not, so just to introduce the plan and the pacing plan, this is something that we present to the IC every year and then bring it to the board, private markets pacing plan. And Dinesh did present this at the IC last month, and the IC adopted it and forwarded it to the board for its formal acceptance. So before I hand it to Dinesh,
Hey, well, hang on one second, Pramod. Ms. Eaton May, can you hear me?
Yes, I can. Can you hear me?
Yeah, we can. Do you need more time to get your internet stable, your connection stable?
Yeah, I'm still trying. I think we've got it. At least I got back in this time. But I'm still working on just one little minor thing. Do you need
Yeah, you're coming in very garbled now.
Is that better?
Yeah, that is quite a bit better. Go ahead and read aloud your favorite Shakespeare passage so we can tell.
I don't have all my Shakespeare phrases right here at my fingertips, but hopefully you can hear me clearly.
Yeah, Maytak, is she coming through garbled to you too?
Yeah, a little bit muffled, yes.
Yeah.
Okay, can I work on
Ms.
this for just a second? I'm going to see.
Yeah, Ms. E, may take your time. I think it's important that we have a really good connection, and we can just go on with our agenda. Let us know when you have a good connection.
Okay, thank you very much.
Sure,
Yes,
you're very welcome.
And Council Eden may I suggest what you may want to do is to mute yourself on Zoom and call in so you have a more secure audio by phone.
Yeah, okay, I'll give that a try if I can't get this ready.
Okay, thank you.
Thanks.
and-
All right. Hey, Prabhu, let's go ahead and then go to
Drew,
item 2B.
I'm sorry, Mr.
All right.
Chair, can I interrupt for a second
Yeah,
and
go ahead,
suggest
sure.
the private markets pacing plan presentation is going to take a few minutes. It's not going to be done
Okay.
in 2 or 3. And I will hate for the board to have to stop the presentation to
Recording in
migrate
progress.
to another item. So can I suggest, and of course, if council thinks this is not appropriate, to try to tackle like quick items, like for example, the Aura update by the CEO and others that would just be a matter of a couple of minutes, because I'm almost positive that if we initiate the private markets, we're going to interrupt them right through the presentation.
Yeah, I think that's smart. And as I look at this, Roberto, your oral update and Pam's may be the only short items left on the agenda. Besides announcing retirements.
Yeah, there might be there's probably another one on the new business for the extension of the contract for the communication consultant. That's just another 2 minutes.
Okay.
I'm just trying to
go
figure-
ahead. Hey, why don't we go ahead then? Let's follow that advice, Roberto. Why don't we jump to 4A, your oral update right now?
Yeah, thank you, Mr. Chair. So
Sure.
you may recall that at the last meeting, your board approved the fiduciary insurance, and I think as council explained, there are three different agreements for fiduciary insurance. And council also explained the concept of the waiver of recourse fees. There are $25 due for each one of the three agreements that we have, which means for the coverage is a total of $75 payment that needs to be made individually by the trustees. So what I suggest you do, if you made the payments, fantastic. If you haven't, reach out to the office. We'll put you in contact with the accounting department and Benji so they can provide you with the information and where you can be mailing your payment. If you want to mail it, it's to our regular address, which we can provide you, 1737 North First Street, Suite 600. And again, it's $75, and it's a payment payable to the City of San Jose Federated City Employees Retirement System. It needs to be available by May 31st. I also wanted to let you know, I think it's in the newsletter, we issued the spring edition of the Quarterly Retirement Connection. Again, I just want to publicly thank not only the work by staff and our communication consultant, but it's spearheaded by Barbara Heyman and Linda Alexander. So I want to publicly thank them for their work on keeping this information, critical information, to the members available on a quarterly basis. And I also want to give our CIO this a very short article, kudos to Prabhu Palani for the article where he was, I forget the specifics, Prabhu, maybe you can help me, you were selected. Who provided you the award?
Well, you're embarrassing me, Roberto, but it was last year, and the markets are very different this year, but it was from TI, Trusted Insight.
Thank you. So I just wanted to call kudos on that. And then lastly, I want to let you know a couple of things. The city lifted the mandatory masking policy at the city locations. A couple of staffing updates. We did onboard a network technician, Chris Ha. He started last month, and we just welcomed this week a new IT manager. Shilpi is her first name. Last name, I apologize if I'm not pronouncing it correctly, but I think it's something along the lines of Divedi. In any case, 27 years experience in the IT industry. She just joined us from PBCE. She started there in 2015, and again, welcome. In addition to that, benefit staff is actually onboarding 2 new members to the staff, and their names are Tracy Tanner and Tara Tran. Again, 2 new members to the benefits group, so welcome to both of them. I also want to let you know, give you an update on Medicare B reimbursement. The deadline for reimbursement form submission was April 1st. We actually received 806 reimbursement forms. 606 of them have been processed through April. The remaining 200 will be processed with the May payroll. So if you have any questions, if you have submitted a payment again, reimbursement for payment, if you haven't received that yet, again, 606 in April, and 200 will be made. But if you have any questions, please feel free to contact the office. And lastly, and Linda, I just want to make sure that I sent you an email, but I know it was late. The clerk of the office has reached out to trustees about filling out the conflict of interest form in the clerk website that was due for April 1st. Is that form, that's a separate issue from Form 700. Is that correct, Linda, or is it the same thing?
That's correct. It's separate.
Is separate. So if you have received an email from the clerk's office asking you to fill out the conflict of interest form found on the clerk website, please make sure you go through it. If you have any questions, please do not hesitate to contact us with questions. And lastly, just want to remind you, staff continue attending the office 2 days a week. And we actually had a soft opening of the office. We haven't advertised it, but we do have doors open now to the office from 9 a.m. to 4 p.m. That, Mr. Chair, concludes my update. I'm happy to answer any questions. Drew, you're mute.
Any questions for Roberto? Thanks, Roberto. If not, Ms. Eaton May, let's try again. Can we hear you? Ms. Eaton May. Oh, try again.
I'm here. Can you hear me?
Yeah, you're still pretty muffled.
Do that before I dial in.
All right, well, let's give it a try. Everybody remember to stay on mute so we can hear Ms. Eaton May clearly. If there are no questions for Roberto, then let me kick off item for you. I've got something to read, but I've got a little preface before I read it. First and foremost, we are an agent of the state. And because we are an agent of the state, we owe due process rights to the two gentlemen we're about to discuss. So the core of due process is notice. Well, we've done that. And the ability for them to appear and to contest and have counsel and call witnesses and question stuff. So I would say to our counsel and you, Ms. Eaton May, and to your client, if at any time you feel like we're not observing due process, by all means interrupt us and point it out to us. We do actually have a process every month where we have to follow due process. It's our disability committee. It's very ably led by Trustee Dick Santos, who makes sure people know they have to be there. We accommodate them if they can't be. They bring counsel. We have witnesses. So we're used to this process, but a disability application is something quite a bit easier, I think, than the cases we're going to hear today. So let me move on to the frame for this. Our counsel, Maytek Chin, is going to explain to you in a minute, but I cannot highlight enough, as she's pounded into me, as has Harvey. You know, there are two justice systems in the country. There's the criminal justice system and the civil justice system. And I think we're sitting somewhere, our board right now, with what we're about to do in the civil side of things. Well, I'm a venture capitalist. That's the only place I live. The criminal courts have already had their due. You've read the briefs and so on. So we're outside the criminal justice system. We're in the civil justice system. So we're not talking about punishment. We're talking about damages. I think our job today is to figure out there was a contract involved and so on. So let's not think that we're here to impose punishment. We are not. Our civil courts, our criminal courts rather, have already done that. And finally, before I sort of go to my thing, two quick things. One, as I said before, we have this sort of general Zoom philosophy of interrupt and ask questions. Let's be a little more formal today. Let's not interrupt counsel, either Chin or Ms. Eaton May. Let's let them do their thing before we do that. And secondly, I cannot thank you, Counsel Chin and Counsel Eaton May. The briefs that you prepared were well written. They were easy to understand, especially Ms. Eaton May. Thank you for highlighting in the middle of your brief what you thought the salient issues were. That enabled me to do a bunch of homework over the weekend. And I really thank you. It was clearly written prose. It was easy to grasp what we're getting at.
Thank you.
So now I'm going to read a formal intro, and then I'm going to turn it over to our counsel, Maytek. So we'll be hearing two matters scheduled for a time certain in items 4E and 4F. These two matters involve the application of San Jose Muni Code to two members for the potential cancellation and termination of retirement allowances convicted of different felonies. Because these two items have been agendized separately and involve the application of the Muni Code to two different members for two different felonies, it's important, Maytek points out to us, that we keep our comments and consideration of each matter separate and distinct. There will be, I suspect, a little bit of overlap, but I think Maytek is saying, let's focus on the particulars of each case. Now, we have a court reporter present, right? Maytek, nod your head up and down.
That's correct.
Great. And this reporter is authorized to swear in witnesses who may present, including the member, Mr. Gallagher, at the request of the board. because we have a court reporter present transcribing everything, again, let's not interrupt, let's not talk over one another. We will do the round robin as appropriate. We'll do raising hands when it comes to the public. So for each item, we will have the following format. Council Chin on our side will go first. Then Council Eaton May will go second. And then we'll let them go back and forth to rebut and answer each other. Then I'll open the floor for public comments, and then we'll have a slightly more formal way of going around the board. Anything else you want to add before you begin, Maytak?
No.
Okay, over to you, Maytak.
I do have a question if I can.
Oh, sure, go ahead, Miss May.
Yes, and so after as part of my presentation, I would be introducing Mr. Gallagher or any statements or anything.
I can't understand her, Chair.
Yeah, try again, Ms. May. It sounds like you're far from your microphone.
Okay, let me see if I can get this better. Is this better?
Oh, that's quite a bit better. Yeah, I mean, you may have just been far from your microphone. Try now.
I just wanted to clarify that as part of my presentation will be the opportunity to have Mr. Gallagher make statements.
Oh, 100%. You bet.
Okay, all right. And I
That's
think
great.
it's a matter of being centered. So I'll try and center a little bit better, see if you can hear
Boy,
me.
it's night. You're right, and it's night and day. You're coming through loud and clear now. So over to you, Council Chin.
Thank you, Chair Lanza. Before I begin, I note for the record that the board received materials from both the Plans Council and Council for the Member for consideration before today, which will be available upon request under Government Code Section 54957.5. Now, this matter has been noticed under San Jose Municipal Code 3.36.830, and I'm going to share my screen. And let me know if you could see it. Can you see my screen?
Yes.
We
Yes,
got
we
it,
can.
Maytak. Thanks.
Okay, great. So as you can see here, this is Exhibit K to the materials that the Plan Council has provided to the board. As you'll see that the matter has been noticed under San Jose Municipal Code 3.36.830 for the cancellation and termination of service retirement allowances due to Mr. Gallagher's felony conviction. Now, this municipal code is the controlling provision that governs the matter today. As specified in this notice, this matter before the board only regards the cancellation and termination of retirement allowances paid to the member due to his felony conviction. Now, last month, I provided a presentation of the overview of pension forfeiture laws. And what I would like to do today is to provide a refresher for the board. So as you see here, the member must satisfy all conditions to gain a vested right to a public retirement allowances. And so all conditions to the employment must be satisfied before the member gains that right to a full vested right to a full pension, excuse me. And this is going to the point that Chair Lanza had spoke to, which regards a sort of implied contractual right in a vested right sense, that the terms of the employment and the terms of the city charter and the San Jose Municipal Code are part of the terms of employment that the member must satisfy as a condition to receive a full benefit from this board. Now, as you'll see here also on this slide, and supported by the materials provided to the board, the San Jose City Charter since 1916 has conditioned the right to a public pension based on the member's agreement not to commit a felony or treason. This condition has existed on the books for all members since the beginning of the city of San Jose. Now, in 1960, the city council delegated to this board the discretion to apply the pension forfeiture provisions to any member convicted of a felony or who commits treason. Although the provision has been renumbered throughout the years, the current version, which has been on the books since 1962, but renumbered and amended in 1993 to become gender neutral, but otherwise the same in substance to the 1965 version, has been on the books and been a part of the members' Member Gallagher's employment agreement. As you'll see here, here are the key points from the San Jose provision at issue, which is section 3.36830. And the key points are, if a member is convicted of a felony or commits treason, the board has the sole discretion to determine whether to apply the section. The member's spouse and or minor may still receive benefits in the board's discretion if, one, an application is made to the board for such payment, and two, the payment needed is for the necessities of life as proven to the board for the spouse and or the minor. And lastly, survivor benefits and death benefits remain unaffected, and that's provided in the statute. Now, as I mentioned earlier today, the issue, as noticed before this board, solely regards the cancellation and termination of retirement allowances paid to member Gallagher due to his felony conviction. If the member's spouse and or minor or other beneficiaries seek to continue to receive such payments, if the board decides to apply the forfeiture, that is a bifurcated proceeding, and that would have to come via a separate application. So I wanted to put the guardrails and scope out the issue before the board, which is that we're limited to the payment of retirement allowances to the member here at this proceeding. Now, the board's discretion is guided by existing case law. Oops, I'm sorry, put the wrong page. And an existing case law provides the guardrails for the board's exercise of discretion. As you'll see here, there are four things that arise out of the case law, the existing body of case law that guide the board's exercise of discretion. One, appeasing public opinion alone is insufficient justification. So for example, if the application of the felony forfeiture provisions here in the San Jose Municipal Code were only applied for punishment or only applied for politically motivated purposes, then that would be insufficient. But if it was one of many considerations that the board takes into consideration, then it may be part of, it would not undermine the board's application. Two, pensions are awarded for faithful and conscientious service, and pension forfeitures are appropriate for a breach of trust. So this goes back to the issue of what were the terms of employment and what did the member agree to do in exchange for a vested right to a full pension benefit from this fund. Three, felonious or treasonous acts must occur before the member reaches retirement status. So the timing of the conviction and the timing of the retirement status achieved is material. And four, the board may return some or all of the member contributions if it decides to apply the forfeiture provisions. Now, based on this information, we have certain required findings, as the board may recall. One, which seems pretty obvious, the member must have been convicted of a felony or treason. If the member had not been convicted of a felony or treason, or the conviction was reversed for any reason, the board may not apply San Jose Municipal Code 3.36.830 to the member to cancel or terminate any portion of his or her pension from this plan. And as I mentioned earlier, two, the convicted conduct must have occurred before the member reached retirement status, meaning the date on which the board approved the retirement application. So that's the main date that we're going to be focusing on. These are the two required findings that the board must consider and decide before it can even apply the statute or municipal code as a threshold matter. Now, the board also has the discretionary authority and may consider the following in determining whether or not to apply the statute. So, the municipal code. One is that whether the member provided faithful service while employed by the city of San Jose. 2, the job connectedness, meaning whether the convicted felonious or treasonous conduct occurred during the course of the member's duties or services as an employee of the city of San Jose. 3, other equitable considerations the board may consider, which include the gravity of the felony or treasonous conduct, the passage of time, whether the member has served their punishment, the member's health and financial conditions, among other equitable considerations. The board may also consider whether to cancel all or a portion of the service disability or disability retirement allowances, and the board must also determine effective as of what date, if it should decide to apply the municipal code provision. And if the board decides to apply the provision, the board may then further consider whether to return any portion of the member's contributions, and with or without interest. And lastly, given that the San Jose Municipal Code provides that survivor death benefits are unaffected by any application of the municipal code, to the extent, because of that, the board must also consider how it will continue to fund those benefits if member contributions are returned and if the board decides to apply the municipal code provisions. Now, going to the facts particular to this item and to this member, Stephen Gallagher, the parties do not dispute the basic facts. The parties agree that Mr. Gallagher retired with a service retirement with 22 years of service, over 22 years of service, I'm sorry. As you'll see in this memorandum provided to the board, in the pages 1 and 2, it lays out the basic summary of the members' information. The parties do not dispute that Mr. Gallagher was first employed with the San Jose Police Department and the city of San Jose on February 28th, 1983. Mr. Gallagher entered a guilty plea on February 9th of 2005. Mr. Gallagher then separated from city service in March of 2005. And Mr. Gallagher then applied for service retirement in 2010 and had an effective retirement date of September 2nd, 2010, and began receiving benefits from this plan at that time. Now, as you'll see here on page 2 of the memorandum, it outlines the benefit information for this particular member, Mr. Stephen Gallagher. And it also provides information regarding Mr. Gallagher's criminal conviction, which was under Penal Code Section 288, letter A, subdivision A, for sexual conduct with a child under the age of 14. And one thing I do want to note for the board before I turn it over to Council Eaton May is that it appears from their material submitted to the board that Mr. Gallagher was a detective in the child and elder physical abuse detail during his time as a officer with the police department. With that, I'll stop sharing my screen and turn it over to Council Eaton May.
Good morning. As soon as you made that switch, we had another glitch. Can you hear me now?
Yeah, when you get right in front of the mic, you're loud and clear.
Okay. Good morning, everyone. My name is Denise Eaton May. I have Mr. Stephen Gallagher here with me. He is visible in my screen. And I'd like to take the opportunity to present our position with respect to the legality as well as the viability of applying Code Section 3.36830 in this particular facts and in this situation. I would like to request if I could share my screen. I have just a quick outline of my presentation that I wanted to go through online.
It's coming. Yep, we can see it now, Counselor. Thank you.
Okay, let me get the right one.
Yep, we've got it again. Thank you, Counselor.
All right, I'm coming. Thank you so much for your patience. Technology has challenged us all this whole couple years.
Well, as we like to say here in the Silicon Valley, welcome to the 21st century. Have a nice day.
Okay, I think I got it up. Can everyone see? Can everyone hear me?
We can hear you loud and clear, and we've got it full screen. You're doing great.
Thank you. So again, I agree with council that there's no major conflict or dispute regarding the facts. But I think for us, the issue is a little different. We believe that Mr. Gallagher provided services to the city for compensation. That compensation included that salary that he received while he was providing services, as well as the retirement benefits, which we believe and see as deferred compensation. So that particular contract is based on receiving the salary for working at that particular time, as well as the retirement benefits, assuming he meets the plan requirements. So during this particular period, Mr. Gallagher earned 22 years of vested retirement service credit. He applied for service retirement in 2010, and after the board determined his eligibility, qualifications to receive the service benefit, Mr. Gallagher began receiving those benefits on September 2nd, 2010. Then 11 years later, after commencement of his retirement benefits, he receives a letter from the board, your board, indicating that the board would conduct proceedings to determine whether to terminate or cancel his service retirement benefits that he had been receiving for over 11 years. We find this to be problematic. One of the reasons is that we feel that this is an impairment of his contract rights. We also feel like his official job duties, the particular conviction was unrelated to his job, and therefore the conduct underlying Mr. Gallagher's felony conviction was not performed while he was performing his job duties as a city employee. And we find this is critical because in all of the cases, as you will see, all of the individuals whose pensions were forfeited, it had to do with them being engaging in misconduct or committing the felony while they were on duty or having it related to their job duties. We looked all over trying to find, and I may not have done as much due diligence as was necessary, but I did do quite a bit, and I didn't see anywhere where the plan has terminated or canceled any other plan member's retirement or has applied this section, irrespective of its existence at the time that Mr. Gallagher was employed. The issue becomes when it's applied is when the contract is impaired. And our position is that there's really no legal basis or an appropriate basis to apply this provision right now in this particular fact situation. So again, for us, the issue is whether the service retirement benefits of Mr. Gallagher should be terminated or canceled by the board. And if so, if we believe that should not be applied, why not? So we believe that applying the charter, which we believe is where you get the authority for the municipal code, Charter Section 1504E and Municipal Code 3.36830, has some problems. It's inappropriate and problematic for several reasons, which I will show as we move forward. The first reason is that we believe that the charter section as well as the code are unconstitutionally vague, ambiguous, and overbroad. The second issue that we look at is, as applied to this retiree, is it constitutional? We do not believe it is so. So it's vague in the sense of what felonies qualify. It just says a felony or treason. What's the difference between a DUI and a manslaughter? The whole idea that you can judge which felonies are applied to be terminated or canceled, I think creates a problem. Also, it's ambiguous. Does the statute that refers to the person, as it states in the statute, apply to all employees or just law enforcement? Disability retirement, I know there's another section on that. And then what is the criteria? I think there is some vagueness and ambiguity in the statute itself that is subject to challenge. We feel it's overbroad. The sections include persons who are receiving pension benefits who commit a felony, which means that retirees who commit felonies after retirement may be subject to cancellation or termination of benefits. This is illegal unless you can meet the criteria and do the constitutional analysis under Alameda County case. And so as we go through that, I think we'll be able to see that our approach is, this particular statute seems awkward, and I think it's subject to constitutional challenge. Notwithstanding, there's some other reasons as to why it is inappropriate for it to be applied in these situations, or in this situation regarding Mr. Gallagher. As you've been briefed, the relationship with respect to the employee and employer, in that the employee provides services in exchange for a salary and a pension, is a contract. And we believe that applying these sections will impair the public pension contract. And the Supreme Court has established that any impairment is unconstitutional unless it survives the two-step analysis of the Alameda County case. So in 2020, the California Supreme Court held in Alameda County Deputy Sheriff's Association versus Alameda County Employees Retirement Association, and I'll just call it the Alameda decision, that pension benefits are vested rights under California Constitution, and the constitutional validity of a modification to a public employee pension requires a two-step analysis. And our basis of modification, even though the statute was in existence at the time that Mr. Gallagher was working, it wasn't applied. It's never been applied. And so his standing and his right, his ability to be able to assess the change, which is at this particular hearing, subject to canceling, his only source of income, I think is the basis for what we believe is a modification of his pension. So when we're looking at the two-step process, the court gave us instructions in saying that if the application of the section involves an economic disadvantage, it is to be offset by new comparable advantage for the retiree. Here, we've seen no comparable advantage being given for this impairment of contract to Mr. Gallagher. Second, if there is no offset for the economic disadvantage, is the purpose of applying the sections of the laws justify the impairment of pension rights? Here, we believe that this is being motivated by an improper purpose. And there are several factors that we'd like to point out to you why we've reached that conclusion and make that assertion. First of all, I think that it's been a while since Mr. Gallagher had started receiving his particular pension benefits. So the issue becomes, why now? What happened? And based on my review and research, what happened is that Mr. Liccardo, Mayor Liccardo, was contacted by CNN, and it was right on the heels of the Derek Chauvin conviction, where the public was up in arms that someone like Mr. Chauvin, who has committed murder, may still be entitled to his pension, his public pension. There was lots of concern and issues regarding we have to do something to ensure law enforcement is accountable. And so after that interview, it appears that Mr. Liccardo, Mayor Liccardo wrote in July of 2021, and he articulated why he felt this needed to be revisited. He says that it's an atrocious waste of taxpayer money, deprives our retirement fund of dollars, constitutes an embarrassment to the city. Tax-paying residents deserve better. It's a symbolic importance and addressing the inevitable public outrage. These are all part of his memo that we understand was circulated to you as well as circulated to other parts of the city. And it was the city and him wanting to say, we need to revisit this issue. Under the law, these reasons are insufficient, as your counsel has advised you, for constitutional purposes and do not justify the impairment of pension rights or the forfeiture of Mr. Gallagher's pension. Our other reason is that, and I've noted, kind of hinted on it before, is that it's a breach of contract for failure to pay compensation which has been earned. The background is public employment gives rise to certain obligations which are protected by the contract clause. I cite Miller there in terms of what are earned services. So it is our position that Mr. Gallagher did his part. He served for 22 years, paid into the system, and did his part to comply with the bargain. And part of the bargain was pay me a portion of my salary now and give me a portion of my salary later. That later is the retirement allowance that he has been receiving for 10 years. And to take that away, we believe, is a breach of the contract. He's done his part of the bargain. We need you as the retirement board to ensure that the employer does their part of the bargain and continues to allow him to receive what he has earned and what he was promised. Again, the public pension systems exist to induce and reward faithful public service. You've been given several factors that we'll go through as to looking at how you exercise your discretion. The pension system is also to provide compensation based on years of service and performance. And it is to reward employees for the years of faithful, conscientious performance of public duty. So let's apply that to this situation. Here we have Mr. Gallagher, who has a stellar employment record, had never, no prior disciplinary actions, did his full 22 years, and basically showed up to work every day and faithfully performed his duties. If you were to look into any of his employment records, you'd see a number of accolades, and he'll be able to describe them when he talks and speaks today. He was provided compensation and he did his service. And so his reward for those years prior to his conviction is the pension. And we don't believe that there's justification to terminate or cancel that pension at this time. I know that a lot of the case law that we've been looking at has to do with interpretation of PEPRA as well as other types of systems. When we talk about Wilmot and Wallace and several other cases that I'll kind of go into. And I think that there is a specific provision, your counsel pointed out, that PEPRA is not binding on a charter system. But we believe that the case law interpreting provisions similar to 3.36.830 is instructional and provides guidance on how the court may view the board's action applying this section to Gallagher. In all the cases cited by your counsel, it's important to note that it all involved a crime committed in carrying out official duty. And we also believe that PEPRA is not only instructional, but more than guidance, because it's the state that's spoken on very similar issues. When you look at the law on the forfeiture statute, it's just not a lot out there. And what is out there sets forth clear guidance on how you are to apply these particular types of forfeiture statutes. What's the parameters? What's the notion that you can exercise your discretion? Is it unfettered? Or is it modified by what the court has already spoken in looking at very similar statutes? And our position is we encourage you to look at what these cases say on applying these types of forfeiture statutes and how it would apply to Gallagher's situation and why it does not apply. One of the factors is that it has to be a job-related felony, and it's constitutionally permissible because it's materially related to the purpose of the successful operation of a public pension system. So I think that's a finding that you have to make somehow or another. A, that the felony that Mr. Gallagher committed was job-related, which we contend it was not, and two, that it, is materially related. Being able to forfeit that is materially related to the purpose of the successful operation of a public pension. Okay. When I look at some of the case law, we look at an employee that fails to devote his full time and effort to his job duties, uses public resources in the commission of a job-related felony, the provision of full retirement benefits to that employee, notwithstanding criminal conduct, okay, threatens the integrity and core purpose of the pension system. We're here saying to you that that is not the case here with Mr. Gallagher. As I've indicated, when we look at some of the court cases, they have held forfeiture of portions of public pensions where the Board of Retirement has made a finding after a due process proceeding that the felony was committed in the course of and arose from the performance of the employee's retiree's official job duties. Now, if you were to exercise your discretion, we believe that under these circumstances of Mr. Gallagher, it would be an abuse of the board's discretion to do so, and certainly subject to further litigation. One of the issues is why apply the statute now when the board has not applied it before? I've looked at all your minutes. I didn't see it being applied before. And although there have been other instances of felony convictions, there's a number of people in your fire department as well as in your police department who have had convictions and continue to receive their pension. Why now? We believe it's because it is popular and a political issue. It is something that if it was that important, it would have been something on the application for retirement. There would be a process where your staff is screening these applications for retirement for law enforcement individuals who have committed a felony. None of that seems to be in existence. In fact, you only came up with a process to understand the due process out of HIPSTR just in April. So we believe this very suspect as to why this is coming up now. We believe that's motivated by public concern, public outrage, the general climate of addressing law enforcement officers who commit crimes, and that is not a proper purpose. It has to be under the Constitution related to the operations of the board, as well as not about public outcry. The other thing is the board took action and approved the retirement allowance of Mr. Gallagher 12 years ago. The decision regarding whether his pension should be canceled or terminated has already been made. And there's no reason to change except for the recent public outcry or political reasons, which we believe under the Constitution are improper. Another issue is sort of the idea that the board just got notice in the letter dated September 8th, 2021 that Mr. Gallagher received. The board indicated that they just had been notified of the conviction. We find that very difficult and hard to believe because the department certainly had notice of the felony conviction. But when we look through the records, we find that Mayor Liccardo was the attorney on Mr. Gallagher's defense team. In addition, he was on the board as a city council member and seconded the motion to approve his pension. So to say that you're just now finding out, we just feel like that is not really a correct assertion. I think the real issue is you're just now applying it because there's some kind of pressure coming from somewhere to now look at this statute and apply it to these particular individuals. And Mr. Gallagher has relied on this. He did not pay into Social Security. This is his only source of income. And he is believing that his promise that he made for his 20 years would give him this pension. And to take it away now, I think would be a substantial hardship, as you would hear from Mr. Gallagher. Again, this is more detrimental reliance. I relied on the promise. I've been receiving it for a decade, and we can't understand the justification that can support terminating the retirement benefit that he's been receiving for all these years. Now, do you have discretion to do it? The statute says you does, but is that an abuse of discretion? Is it fair? Is it equitable? Is it something that really is going to contribute to the operation and efficiency of the system? Not under these circumstances. There's no criteria as to whether it's a sex offense or murder or manslaughter that qualifies for terminating or canceling. The guidance from the courts is that it must be job related. And we encourage you to apply that standard when you're looking at whether to apply it to this situation. So the other issue is we believe there has to be some concern with the constitutionality of the 1504 as well as the municipal code section. It is broad. I'm not sure how you can decide, how you can second guess the pension system and say, oh, this is the kind of felony we want to terminate or cancel, but not this one because it doesn't necessarily bother us as much or bother the public. We think that particular type of analysis has some constitutional problems. So in conclusion, I'd like to just summarize real quick and be able to give you an idea of what, in summary, our position is. So, using the legal standards articulated by the courts, the application of the Municipal Code Section 3.36.830 is an unconstitutional impairment of the rights of Mr. Gallagher, as well as if we were to apply that, we would believe it is an abuse of discretion. Why do we believe that? We believe that because the evidence shows that there is an improper purpose. There seems to be a lack of material relation to the theory or operation of a pension board. It appears that the board is seeking to enforce a second punishment. Mr. Gallagher has done his time, paid his debt to society. He has completed parole, done everything that the penal system that's designed to address criminal behavior has done. He did not work any longer after the conviction or the commission of the felony. And so there's no employment issue. The issue is the retirement contract. And that's a different analysis than whether you're trying to lose your job or convicted of a crime. That analysis has to do, can I change the contract that we promised Mr. Gallagher when he provided faithful service? Can I change the contract at this time because of his felony? And the code says, and the Constitution says, it has to be for a proper purpose. And we don't believe there is evidence of any kind of proper purpose other than political reasons such as taxpayers' concerns and all of those items that Mayor Liccardo put in his memo. We also believe that the law provides if you eliminate Mr. Gallagher's pension, you have to provide him some kind of comparable new advantage. And in this case, we have nothing in the correspondence from you that you're going to impair his contract and take something away that was promised to him, but not give any corresponding or comparable new advantage to offset that. We believe that's a constitutional problem. We also think that the law supports that if you want to make modifications to a person's pension, not only just to the plan. And again, remember, my position is as it is being applied, it's a modification. Even though it existed before, it's still a modification because it was not enforced. And I don't think it's ever been enforced up until this time. But if you're going to do that, you have to do that before the pension becomes payable. And here, I don't think the evidence shows that he received the pension for 10 years. So to come back and change it now certainly has a detrimental impact. And we don't believe that will pass court scrutiny if we were able to have a court review it for him having his pension taken or removed after he has already begun to pay. And again, it's because he's already performed the public employment, which gave rise to the city's obligation in exchange for his services. And finally, we believe the statute is, as I've hit on several times during this presentation, the statute is inapplicable because the guidance that is given to us by the courts is that it be related to his job. And this particular felony conviction was not within the course and scope of his employment at all. So we would just ask, and I'm going to give Mr. Gallagher an opportunity to speak, but we would ask that should you, whatever decision you make, we'd ask you codify it or memorialize it in some kind of statement of decision, letting us know, why you felt this was appropriate, the reasons for the decision, and the description of what evidence you relied on for that decision. And I think that's important because based on my knowledge, and I stand, you can correct me if I'm wrong, I didn't find where this has been applied before. I didn't see where this has been done before. And so this is sort of a first impression, and we want to be able to truly understand this and protect Mr. Gallagher's rights should he have to seek further appeal. And I just see a typo. I apologize for that. It's part of our rushing getting things done. At this time, I'd like to ask Mr. Gallagher to make a certain statements. Is there a desire of the board to ask questions before, or can we wait until after he makes his statement?
Why don't you and Maytac hold the floor, Ms. Eaton May, until you're both done?
Okay. So I'm going to stop sharing now. And hopefully you can hear us both. Can you hear me?
Yeah, loud and clear. When you speak, Mr. Gallagher, put your head roughly where Ms. Eaton May's head was. She was coming through loud and clear.
No. Okay.
I know.
Hi, how about now?
Oh, that's perfect. Thank you, Mr. Gallagher. We hear you loud and clear.
Are you gonna ask me a question? We get to put our heads together.
Okay. So can you hear me now?
Jeez.
Are we still muffled?
No, Mr. Gallagher was coming through loud and clear just then. Wherever your head was a minute ago was perfect.
Okay. I'll let Mr. Gallagher go forward. Go ahead.
Okay. Good morning. I had a couple of issues I want to discuss with you. One is the course and scope of employment. The felony that I was convicted of was not in course and scope. And in several cases I've been cited about that. The first case was Hipsher. Basically, Hipsher was a firefighter who was running a gambling operation out of the firehouse. And the retirement board determined that that was course and scope. Hence, he lost his pension. Dancer was a Santa Clara County judge who was conspiring to obstruct justice from the bench. So PERS decided that was course and scope of employment. Wilmot was a firefighter, I believe, in Contra Costa, who had been stealing from the firehouse, and he retired. And they, under using the PEPRA standards, they eliminated his retirement from the day that the crime was discovered 10 years prior. Now, finally, Wallace was the chief of police in Fresno, who, after he retired, committed tax evasion. The city of Fresno tried to take his retirement, and the court concluded that it was not within the course and scope of employment. And now I want to talk about knowledge of this crime. When Mr. Pena contacted me back last summer, and he was very helpful in that, he said that he didn't know that I had been convicted of a felony. And I totally believe him because he wasn't working here 17 years ago, I think. However, former district attorney Sam Liccardo was on the prosecution team in my case. And he also was represented the people at the restitution hearing in my case. 5 years later, less than 5 years later, he was the person who seconded the motion for my retirement. And on that particular board were police officers who knew about my case. And in the audience was the deputy chief of police, who was the IA lieutenant or internal affairs lieutenant. So he knew about my conviction. Nick Bustillos, who was personnel, knew of my conviction, and no one raised this issue at that time. So in my opinion, this is a done deal, and my retirement was granted without a 6-0 vote, including Mayor Liccardo. So I don't understand why Mayor Liccardo is claiming that he had no knowledge, because it's a small world, and he certainly had knowledge. So I think he's either has amnesia or he's being dishonest about this whole thing. And he's put this on you to revisit something that had been settled 12 years ago. So to do that, I believe would kind of erode public trust in the board's decisions, because they're going back on what they have already been committed to do, or predecessors, I should say. For me, it'd be a substantial detriment to my lifestyle, because it's the only income I have. I don't have Social Security. In fact, I'm paying out of pocket for my Part B Medicare. I'm also paying child support to my adult daughter because she still hasn't completed high school. So if I lose that, that'll be a detrimental impact on her as well as myself. My health is not in the best condition, and I really can't re-enter the job market in my mid to late 60s. So in conclusion, I'd have to say that if the board chooses to withdraw my benefits, I guess we'll have to litigate further. But to claim that my felony conviction was not known is ridiculous in the face, and the evidence provided here shows. This action would erode public trust in the board among workers and citizens. To withdraw pension rights for an incident that is not within course and scope of official duties would not only be unlawful, it would pauperize an elderly widower with health issues, which is not only wrong and shameful, but inhuman. Thank you.
So do you want to yield back to opposing counsel, Ms. Eaton-May? So it's not opposing, we're trying to find the truth here. Do you want to keep going? Or you want to turn her back to Maytag? Oh, you're garbled. There you go. Try again. Hang on.
All right, am I better?
Yeah, it's something, it's really directional. You're great now.
Yeah, I don't know what's going on. I've shifted and unplugged and plugged everything, and I do apologize for this mishap. But I did want to put just a few things on the record with Mr. Gallagher. I don't know if we can do this because of the speaker situation. So why don't I give it a try and see if you can hear us?
And Chair Lanza, as she's getting ready, I do
Sure.
want to just reserve a few not rebuttal points, response points is when she's done.
Oh, yeah, I think Maytag, the general gist is we'll let you two go until you think you've completed, and maybe that means you're debating, and maybe it means you're just staying further. And then I think I think the board wants to be fully informed before he starts to go.
So, Mr. Gallagher, what was your understanding of how the retirement benefits that you were promised when you were a police officer would work?
My
I'm
understanding,
sorry, I'm sorry, Miss Eaton May. We couldn't hear the beginning of your question. If you could please sit a little closer. I just want to make sure the board has full question and answer before it. Thank you.
Absolutely, no problem. My question was, Mr. Gallagher, what was your understanding of how the retirement benefits you were promised as a police officer with the city of San Jose would work?
as I understood it, if I put in 20 years plus, I'd be vested, would receive 50% of compensation upon retirement age. For any additional years, I would receive a larger percentage until retirement age.
Chair Lanza, may I have a question to Council Eaton May?
Yes,
Are you okay with that? Go ahead. Yeah, you guys go back and forth, however you want to do it.
yes,
Sure. Council Eaton May, are you intending to question the witness before the board?
yes, I am.
For Chair Lanza, may I recommend that we have the court reporter place the member under oath so that the question and answers are sworn under penalty of perjury?
Yes, I see the court reporter there. That's okay with you, Ms. Eaton May, right?
Yeah, that's fine.
Okay, get ready, Mr. Gallagher. You're going to be sworn in again. Go ahead.
Would you raise your right hand, please? Do you solemnly state, under penalty of perjury, the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I so swear.
Well, that's unusual for a board meeting. Here we go.
May I proceed? Okay. So my question, Mr. Gallagher, was prior to your separation date, do you believe that you served faithfully?
I'm sorry, that's
Can't be heard.
can't hear.
All right, can you hear me now?
Yeah, it's something you got to be right in that location and face up. Yeah, sorry.
Oh, this is right. So my question is, prior to your separation, do you believe you served faithfully and why?
Yes, I do. I reported to duty on all of my assigned tasks and completed them well. I've never had any problems in my work. And also faithfulness, duty, and police work and fire work is more than just showing up and doing your job. I spent a considerable amount of my off-duty time preparing for the job through studies and also physical exercise to be prepared for the rigors of the work.
Mr. Gallagher, if your pension was terminated or canceled, how would that impact you?
That's my only source of income other than a few shares of stock. It would impact me. In fact, I couldn't meet my mortgage payments and car payments because I've encumbered myself under the faith that I was going to receive my pension for life. I also provide child support to my adult daughter, and I intend to put her through college if she elects to go. So that would also be impacted.
Mr. Gallagher, do you believe that the felony conviction that you were assessed was job related?
Absolutely not.
Why?
Well, first, it was a private family matter. It did not occur within the jurisdiction of San Jose, and I was not an employee or working at that time. It was in my off-duty time.
That's all I have right now.
Good, Maytag.
I'm sorry, Council Eaton May, I couldn't hear. Are you concluding your comments at this time?
That's all I have right now, yes.
Okay, thank you. I do have a few response points that I want to make. First, I want to make clear that I'm serving before the board as fiduciary counsel and general counsel to the board. I want to make clear for the record that I am not appearing as advocacy counsel. Therefore, I have no recommendations to the board on whether to apply the forfeiture provisions to Mr. Gallagher under the San Jose Municipal Code. My job here today is to provide the board a summary of the materials that both the member and the planned council has submitted, as well as the state of the law, and to answer any questions that the board may have regarding those legal issues. Now, in response to some of the legal points that Council Eaton May has made, first regarding the constitutionality of the San Jose Municipal Code and the city charter, there's a case out there from the California Supreme Court called Lockyer, where the California Supreme Court has held that an administrative agency is without jurisdiction to declare a statute unconstitutional. Under Lockyer, as you guys may recall, many years back, there was Prop 8, which made marriage between same-sex couples illegal, and Mayor Gavin Newsom at the time had declared that Prop 8 statute unconstitutional and refused to enforce it in the city of San Francisco's jurisdiction. The California Supreme Court said that Mayor Gavin Newsom and the administrative body did not have jurisdiction to declare the statute unconstitutional. That is within the providence of the courts alone. And so based on that ruling, it is incumbent upon this board to apply the statute as written until a court of competent jurisdiction has declared it unconstitutional. Until then, the statute remains constitutional as it's on the books. Number two, regarding the vested rights doctrine, which is that if there's an economic disadvantage to a member due to a legislative change affecting retirement benefits during the member's career, then, only then, may the board or the city provide a comparable advantage to offset that economic disadvantage. The key issue here for a threshold issue here before the vested right doctrine applies is to determine whether there was a legislative action that affected the member's retirement expectations in terms of benefits he or she may obtain. And here, as members council Eaton May has admitted, the city charter provision and the San Jose Municipal Code provision before this board in this matter were on the books and in existence at the time Mr. Gallagher entered the force as a officer for the San Jose Police Department, and has been on the books ever since then. The fact of whether or not those provisions were enforced is immaterial under a vested rights doctrine analysis, because there has been no legislative change to substantially or materially affect his benefits. Therefore, this board does not need to consider whether a comparable advantage was provided to Mr. Gallagher, because if it so decides to apply the provisions, because there has been no legislative change. Third, one other point I want to make is that this board is separate from the city. We are trustees of the plan and we are fiduciaries of the plan. Any comments made by Mayor Liccardo in his capacity as a mayor and in representation of the city are not imputed to this board, though the board may consider those comments. As counsel for Member Gallagher has noted for the record, ORS did become aware of this felony conviction for Mr. Gallagher at the same time that Mayor Liccardo was contacted by a CNN reporter regarding his conviction. Now, one thing I want to note for this board, and as we discussed at our prior meeting when we did the overview for the pension forfeiture law, the city of San Jose does not have a felony conviction reporting structure. So if a member convicts a felony, there's no way for that information to be collected and reported to this board. And this board and ORS does not have a reporting mechanism to capture that information either. Now, once the board does become aware of a felony conviction of one of its members, the board does have a duty to consider whether or not to proceed and apply the San Jose Municipal Code provisions and the charter to the member, though it does not need to. It simply must consider the matter. and hear from both the plan council and any interested parties, including the member and its council. Now, another issue that I would like to raise for the board is that the city charter and the San Jose Municipal Code, let me just share my screen, do not require a hearing. Let me know if you can see this. Sorry.
Yeah, we got it, Maytag. Thank you.
Okay, thank you. So as you'll see here, the applicable San Jose Municipal Code provision 3.36.830 does not require by law in the text of the statute that a hearing is required before the board takes action. And the same is true with the city charter. Because there is no hearing required by law, this board is not required to issue any statement of decisions, and this matter is a pure writ of mandate issue where the board's actions will be judged based on its application of the law. It's not, and one other issue that I want to raise in regards to Mr. Gallagher's comments is that a lot of, and let me just take this down. Okay. So another issue I'd like to raise before this board is that as Council Ian May has acknowledged, and as Mr. Gallagher himself had mentioned, the Hipshire and Wilmot cases were brought under the Pepper statute. And the Pepper statute does not apply to this board. And under the Pepper statute, service connection or job relatedness is a required element in the statute itself. And that is why those cases consider job relatedness in terms of their holdings. The same is true of Dancer, which was the obstruction of justice case. In Dancer, it was a judge who was letting parking tickets and driving tickets off the hook in exchange for certain kickbacks. And so it was an abuse of his office, and the related SORL provision governing the county employees retirement systems, I'm sorry, the JRS, excuse me, the judges' retirement systems required that a certain level of job connectedness in the text of the statute. Now, here, as I mentioned earlier today, the San Jose Municipal Code provision does not include any requirements of job relatedness as a consideration for the board, though the board may exercise its discretion to consider that. It's not a required element, but it is a discretionary element that the board may consider. And lastly, when I want to close out for the board is that I want to remind the board that the reason why we're here today. The main issue before this board to determine whether or not to apply the San Jose Municipal Code provision for the cancellation and termination of Mr. Gallagher's retirement allowances due his felony conviction. The central question in making that determination is whether or not Mr. Gallagher committed faithful service, meaning that did he discharge his agreement to the terms of his employment set by the city charter and the municipal code to allow him to receive a full retirement allowance from this plan. And with that, I will turn it over to Ms. Eaton May if she has any responses.
Yes, just a few. And hopefully I'm in the right spot so you can hear me.
Yes, we can, loud and clear. I think it's, if you speak down, it hurts, but if you speak forward, it's great.
Okay, great. Thank you. When I raised the issue of the constitutionality of those provisions.
I'm sorry, Ms. Eaton May, I'm having a lot of difficulty.
Okay, thank you. Is that better? Trying to find that spot. Okay, thank you. When I raised the issue of the constitutionality of the charter and code, I wasn't asking you to make that determination. I just think that that is something when you have a statute that's been on the books as long as those have, and you have PEPRA and some of the courts that are interpreting forfeiture statutes, and you're looking at that statute as being applied, that constitutionality is a factor that you want to look at, because that's something that will be raised should this matter be able, have to go further to court. That's one issue that would be raised, and I was just bringing it up to have you take a look at it now to say, you know, maybe this isn't the time to enforce and apply this statute. There may be some more work that needs to be done to ensure this statute and the code will pass court muster. And so that was my impetus in addressing that. Of what I saw.
I'm sorry.
Did I go out again? Ms. Court reporter, did you hear me?
You'll need to repeat that last sentence.
Are you ready? Okay. I was indicating that.
I'm sorry, Ms. May, you need to come a little closer. We cannot hear you.
Can you hear me now?
Slightly.
Can you hear me now? Okay. Good. Okay, covered up the speaker. That better? Okay, I accidentally put my notepad over the microphone. I apologize. I believe what I said was that in looking at the application of the charter provision and the code section, that one of the factors you would look at in a statute that's been on the books as long as that has, to see if it does have any vague or ambiguous or overbroad provisions before you seek to enforce it, especially in a situation where the retiree has already began to receive retirement allowances. So that's what I meant with respect to the constitutional issues that I raised. We believe that there is a vested right issue. I think that
Sorry, we believe that.
there is a vested right issue. And Ms. Chin and I will respectfully disagree, but I believe that applying it at this time certainly creates a deprivation to the retirees that I believe creates a vested right issue. I do understand that the city and the retirement board are separate boards, but I do believe that this board and ORS was influenced by the city's request to take a look at this, the city's request to make 3.36.830 automatic instead of discretionary by Liccardo. And I think the reasons for that request and the impetus behind that was his interview with the CNN reporter, as well as the items that he enumerated in his July 2021 memo, which I did include in my exhibits. I think that's really all I need to.
Sorry. You'd
I
look.
think. Can you hear me now? Am I okay now? I'm not
Yes.
sure why this keeps going in and out, but I will stay at this spot.
Council, when you speak directly to the screen in the microphone, we can hear you correctly. Whenever you have to look down at the notes or you look any other place that is not straightforward, we lose the voice. That's what's happening.
Okay. All right. I will just pause and take a look at my notes and then speak rather than speak from reading.
Yeah, let's try that. Well, I think that'll work. I agree
Okay.
with her.
I think the reason why we were requesting, and I kind of reiterate this, some type of statement of decision is because we believe that there's a detrimental loss to Mr. Gallagher should you decide to cancel or terminate his retirement. And we believe that on the HIPSHR, there are some due process requirements, and that under the law, before you can take away or modify a vested right, it should be some due process. And so that was the basis of why I wanted to ask this board, if possible, to have some kind of decision outlining the basis for its decision so that it can be clear going forward whether Mr. Gallagher has to seek further redress from the courts or try and submit any additional information that might color or be relevant to the board at that time. So with that, and with our connection problems, I am going to submit and see if the board has any questions.
Back to you, Maytak, before I fire the board up.
Sure. I just want to respond to Council Eaton May's last comment regarding HIPSHR and the due process that's required here. As this board is aware, we have adopted a due process policy earlier this year, which provides the basics of due process as outlined in HIPSHR, and which we have also provided to Mr. Gallagher in this matter, which are: one, a notice, sufficient notice of the provision that we're seeking to apply and the basis for that application, which we provided with the materials, and also which I had shown to the board earlier at the onset of this matter. And two, an opportunity to be heard, which, as you have seen here, Mr. Gallagher has retained counsel and has also provided his own comments to the board before the board makes those decisions. Now, those are the two critical pieces to due process that HIPSHR held. As you recall, in HIPSHR, the LaSera board had applied the PEPRA felony forfeiture provisions without providing any notice to the member or allowing the member to come before the board before it applied the statute. And that's why the Court of Appeals remanded the case back all the way down to the LaSera board to try again, to provide the adequate notice and opportunity to be heard. And so with that, this board, in my opinion, has satisfied the due process under HIPSHR. And with regard to the statement of decision, I note for the board that this matter is being transcribed. And so any of the board's discussion and consideration and materials submitted to this board will be a part of that record. Thank you. And I submit to the chair and the board for any questions as well.
So that means you and Ms. Eaton May are ready for the board to jump in, I take it? Good. All right. So let's proceed as follows. Let's break the board's actions into three discrete pieces. Okay. Let's, as Ms. Eaton May and Council Chin just said, let's take questions first, not comments from the board. Questions. Let's try to get all the facts out. Then we'll see if the public has any questions. And then we'll do the second of three rounds in the board. Then let's go around and get the board's commentary, sort of the thinking of the board. And then let's take a break so we can absorb all this. And then we come back, let's open the floor up and see if we can generate a motion of how we should proceed. So I gave to Roberto and Linda earlier, I opened up Excel and I generated random sequences. So there's no bias in how we're going to get around the board. This first round of questions only, not comments, will be Andrew, Franco, Dick, Sunita, Dave, myself, Eshrar, and Howard. So starting with you, Andrew, do you have any questions for either of the councils?
I do. Thank you, Drew, and thank you, Council Eaton May and Council Maytag and Mr. Gallagher for being here and answering all these questions. Just a couple questions for you, and this first one, it could be for anybody. It hasn't been talked about, and that is for police officers when they get sworn in. Is there an oath that they take that is part of their employment? And if so, is there anything in there that discusses conduct outside of work?
So
you want to go first?
Sure, because I have the document open. There is, with the board materials that I have provided, I did include the oath of office. So let me go ahead and share it so you guys can see it. When members do become a part of the force, they do take an oath of office and sign something, which is provided here. So let me know if the board can see this. Sorry, I'm just trying to make it so you can see the entire thing. And so this is Exhibit O to the materials that Plan Council has provided. Now, this is the oath of office that the board, that the member takes. But as I understand it, there is also a handbook of the duties for the police officers. And one of those in the handbook, there is a provision in there that says that the officer does agree to abide by the law in their private life as well. And that may be something that Trustee Votto or Trustee Wilson can better speak to, as they are both representing the police on this board.
If I may respond, in answer to your question, Vice Chair, there's nothing in the oath that says anything about outside conduct. We're not aware of the handbook. It wasn't produced, I think, in this particular exchange, but there's nothing that indicates in the oath about off-duty conduct.
So if there is, I mean, since we don't have that information in front of us, if it is in the handbook, is that something that we should be taking into consideration, since that does talk about off-duty conduct and how that affects employment?
Yes, I do think that's a consideration the board may have. I do see a hand up from Dave Wilson.
Yeah, I think what Vice Chair Gardner is referring to is the Law Enforcement Code of Ethics. It is in our duty manual. And the phrase he's looking for is, "I will keep my private life unsullied as an example to all." Does that sound about right?
Yes,
Okay.
Trustee.
Okay, thank you. Sorry,
oh.
go ahead.
It's our position that the relevant information and guidance to this board is from the courts and the court's decision. And right now, all of the cases that have considered any type of forfeiture, whether it's under PEPRA or something different, have used that standard with respect to the felony being job related. And if it's off duty and unrelated to the job, there's been no forfeiture. So that's our position.
Thank you. And then just one other questions, and I'll have more for the other rounds. In regards to Mr. Gallagher and his comments about hardship and how this would affect him personally and his family, what is that process? I know in our policy that we adopted, there was discussion if something was reduced or benefit reduced, family could come back and file for hardship. Do we take that in consideration now during our discussions, or is that something that gets decided once an application or whatever that process is needs to occur?
So I can take that on, and let me again share my screen. I was just pulling up the relevant provisions. So here, here under the municipal code, the San Jose Municipal Code provision at issue. Let me know if you can see my screen. You guys can see it. Okay, so the board does have discretion to determine whether or not, if in the circumstances, if the board does decide to forfeit or cancel and terminate a portion of the member's allowance paid to the member, the board may, in its discretion, continue to pay the benefits to the spouse or the minor if an application is made to the board for such payments and the payments are shown to be for the necessities of life for the spouse and or the minor. So that's what's provided specifically in the text of the San Jose Municipal Code, because it requires an application to be made to the board after the board has made a decision for the cancellation or termination of payments to the member. This will require a secondary proceeding for that application to be considered. So to your question, in some, it's not a required element, but it may be a discretionary one to determine whether or not, payments made to a spouse or a minor may be implicated, but is not a required one. And to the extent, and the issue of whether the application is made only applies if the board does decide to apply the municipal code provision. If the board decides not to apply the municipal code provision, there's no question regarding the spouse or minor.
Okay. And one more question, and I promise I'll be done. I'll save all my comments for the, like I said, the next round. In regards to time elapsed, it's been multiple years since the conviction was occurred, since he started collecting his pension. Should we be taking that in also into consideration as we have this discussion?
Sure, certainly. That is one of the discretionary considerations. Like I said, it's not a required consideration. To the gravity of the felony or felonious conduct, sorry, tongue twister. The passage of time, whether the members serve their punishment, the members' health, their financial conditions, these are all equitable considerations within the board's discretion to consider. They're not required elements under the statute, but they are discretionary.
Thank you. Thank you for everybody for the comments. I got no more questions. Thanks, Drew.
Thanks, Andrew. You're up next, Franco. Any questions for either council?
I have no questions.
Thanks. Dick, do you have any questions for either council?
Yes. Thank you, Drew. First of all, Drew, I will ask the questions, but I want to commend you and both council on how you're conducting this. It's really helpful because, and it's I want to say, like, as the world turns, this is a really complicated, complex issues because so many issues have been brought up. It's not just cut and dry. So let's go back to whether you're on duty or off duty. As I recall years ago, a police officer was able to have a weapon on and off duty. So therefore they were always on duty. That is a question I have. Was that on duty existing?
I'm sorry, can you repeat your question?
Yeah, the question is, years ago, in my understanding, a police officer was able to carry a firearm, whether they're on duty or off duty. So that's a situation. Does that mean you're continually doing the performance of your job? You are accountable 7/24.
Well, it's our position that a police officer is on duty at the time that is scheduled. They're not on duty and they're not being paid for 24/7. The issue of carrying a firearm is different than carrying out your responsibilities as an employee of the city of San Jose as a police officer. And so we do not take the position that you're a police officer 24/7 all the time and that your duties and responsibilities off duty can be scrutinized for purposes of forfeiting your retirement benefits. That's just not the law, and that's our position.
Well, I would say that we need to check that out as far as the San Jose PD during those years and what was the issue at the time. Were you on duty, off duty to make a difference? You carried a firearm. So I'm just questioning that. That's what this round's about. And that needs to be looked into with the police policy or whatever they have during that time. The other question I have was the board at the time in 205, was they notified of this felony? And
Sure.
when someone keeps on butting in, what, is someone talking? Okay,
Sorry,
let me try again.
Well, Trustee Santos, before you go on, I did want to pull up the duty manual for police officers that Trustee Wilson had mentioned, if it would be helpful for the board to review that.
Sure. Thank you.
Well, our concern, is that part of the package that you exchanged?
No. But this document is judicially noticeable.
Are you saying that you're showing it because it is judicially noticeable?
It is judicially noticeable, and it was put at issue based on one of the questions made by the trustees. But the substance of it has already been attested to by Trustee Wilson. So it does not need to be shown to the board because it has already been attested to.
So you're not showing it?
Well, I'm asking you, do you have an objection to our showing
Yes, I
it?
do have an objection. I mean, we had an agreement to exchange our documents that are going to be presented to the board. And this was not, we have not had a chance to see it or present argument on it, so I would object for the record.
You may proceed to put it up.
Yes, Council Eaton May, I also note for the record that the demonstratives that were presented to the board via your PowerPoint were not exchanged to the board's plan council prior to this proceeding. And so the same objection goes to your PowerPoint presentation. So I
wasn't handed out, Ms. Chen. Wasn't handed out to the public. Whereas now you're visibly showing a document that you are using as a basis to get clarity on the board as to, you know, this particular, the relevance of it. And we haven't seen it. Don't know anything about it. Whereas my argument was simply argument. It was just a presentation. And that's the basis of my objection.
Why don't we go ahead and let's go ahead and not pull it up, Maytag. I think Dave did read the relevant section as part of his question, so I think we're okay. Do you have an answer to Dick's next question?
The next question was, in 205 was the board, or in 210 was the board of retirement given this information that Mr. Gallagher was convicted of a felony prior to his retirement?
Trustee Santos, on behalf of the plan was not given any information regarding Mr. Gallagher's felony conviction prior to being notified last fall in 2021.
Thank you. Like others have said, I'll wait for other comments. This really helps to try to get as much information as possible to understand many of these issues. Thank you.
Thanks, Dick. You're next, Anita.
I had just one clarifying question. Council Maytag, in your memo, it says that the felony conviction was on February 9th and the separation was March 7th. But I also heard that the felony happened after separation from city service. I'm a little confused about the facts.
Sure. So the facts, I think what you're referring to is a reference to the sentencing in Ms. Eaton May's brief submitted to the board. Here, Mr. Gallagher entered a guilty plea, which forms the basis for his felony conviction in February of I believe it's 2010. Let me just pull up the exact, the memo that has the exact dates on it and share it with the board as well. Let me know if you can see this. It takes a minute. So as you see here, the felony conviction by guilty plea was entered in February 9th, 2005. Now that forms the basis for the felony conviction. Mr. Gallagher was later sentenced in May of 2017, on May 17th, 2005. Sentencing and conviction are two separate things. And as you'll see here, Mr. Gallagher was convicted before he separated from service. But the main important issue here is that he was convicted before his retirement application was approved.
If we may respond also.
On February 9th, I made a change of plea. The conviction didn't occur until May, and after that was sentencing.
That's, I don't have that in your criminal record. Maybe place the member under oath to have that presented to the board. I note that the member's brief has no citation for that particular conviction date. So that's an unsubstantiated date.
I don't think Mr. Gallagher was removed or released.
You're in the wrong place again, Counselor. Try again.
Okay, can you hear me now? Can you hear me now?
Yep, loud and clear now.
I don't think Mr. Gallagher was removed from under oath. And if it's okay, we can have him sworn in again, but I think his testimony is still, any statements he's still under oath at this time. And he is correcting the record based on his personal knowledge that he was not convicted in February. There was a change of plea. that he did resign in March of 2005 and was convicted in May 2005. And I believe the entire criminal record was presented, and if we look at that criminal record, it would reflect those facts.
And if I may respond, Chair Lanza.
Please, the floor's open.
Sure. Trustee Ganapati, the main issue here is that all the felonious conduct for which Mr. Gallagher was convicted occurred before he achieved retirement status. And that's the main date on which we determine. It's not separation from the city, it's the date of retirement.
Thank you for clarifying that. That's all I had, Chairman.
Thanks, Sunita. Dave, you're up next. Any questions?
No questions at this time. I'll probably have some comments later, though. Thank you.
So I go next. So we're throwing around precedents. So let's imagine there's 3 boxes we want to check when we're looking for a precedent. I'm not sure I've heard this yet. And the first box is, was this a serious felony committed by a policeman? And I think let's define serious felony as something for which you do time in prison. Could be right, could be wrong. It's my question, what the hell, right? Check box 1. Do we have a precedent where a police officer committed a felony off duty? Check box 2. Police officer committed a felony, did prison time, did it while they were off duty. And then here's the magic third checkbox. It's not PEPRA, either because it happened before the PEPRA statutes or because that officer worked for a charter city and the charter cities are not held to that standard in PEPRA, are not part of PEPRA. It says right in the first paragraph of PEPRA. So again, do we have a precedent, not PEPRA, either because before PEPRA, charter city, of an off-duty officer committing a felony serious enough they did prison time? Do any, Ms. Eaton-May, of your precedents or Ms. Chin, do any of your precedents cover something like that? Do we have a precedent?
And may I respond?
Yeah, Ms. Chin first and then you, Ms. Eaton-May. Go ahead.
Okay.
Sure. So I will say that the San Jose Municipal Code provision 3.36830 has not been applied in such circumstances. And there is a matter of first impression before this board. And so, and there is no precedent from a published court decision or otherwise for this application. Secondly, one other point I want to make clear to the board is that this board is bound to apply the text of that San Jose Municipal Code provisions. Now, each charter city, each, PEPRA, the Pearl applicable to CalPERS may all have different language in their particular felony forfeiture provisions for pension benefits. And so whatever applicable provisions apply, the board is bound to apply those as they apply to their systems. Here, again, this municipal code provision does not require that the felony conviction occur off duty or on duty. And so it's left to the board's discretion on that issue.
So,
Mike,
hang on one second. Let me follow up with Maytag, and then we'll turn to your seat, May. So that's kind of a rather long-winded way of saying you don't know of any precedent of a serious felony that did prison time from someone off duty who's a police officer and was not covered by PEPRA. I looked, I couldn't find one.
Correct, there's no precedent.
Back to you, Ms. Eaton-May. Do you know of a precedent that matches those 3 checkboxes?
no, I don't. I was going to say, when you say precedent, I automatically, my legal mind goes to case law. And so I think I have looked at nausea to find something related. And I did not find where a police officer has, a law enforcement officer has committed a serious felony and did time and was not applicable to PEPRA. Now, we still feel that PEPRA is instructional, and for that reason, because there is no law and particular precedent on this particular situation, the guidance in looking at where we go and how we apply would be those cases that were decided on similar forfeiture statute, maybe different language, but they're similar and they aimed at the same goal. And the criteria that the legislature was using in trying to fill the gap by enacting forfeiture statutes, as well as the case law, is kind of what we believe is the guidance, because there is no precedent that I found.
Great. Thank you, counselors. That's a great answer. Did somebody else want to jump in on top of? No, so I just went Eshfar, you and then Howard last. Go ahead, Eshfar.
Yeah, thank you, Drew. So a couple of questions for Council Chin. First is just to clarify that this discussion and decisions be made, you're going to be guided by the San Jose Charter and the discretion it gives us, correct?
Correct.
Okay, and I think you just said that the San Jose, the code does not differentiate between on-duty or off-duty behavior in terms of a felony.
Correct.
Okay. And do we in this discussion have to consider constitutional issues that Council Eaton May mentioned? Is that part of our responsibility?
No, it's not part of your responsibility. Under the California Supreme Court's jurisdiction or case jurisprudence under Lockyer, this board is without authority to determine the constitutionality of a statute that's currently on the books.
Okay, thank you. That's all I had. Thank you.
Great. Your last, Howard. Go ahead.
Well, thank you, Council Eaton May and Councilor Chin, and also Mr. Gallagher. I appreciate your coming to this hearing. And as Trustee Santos said, there's a lot to absorb here, and it's very complicated. I just have just two questions. One is a detailed question, and I don't know if there's a quick answer. Maybe there is. I read in the retirement application that there is a San Jose Municipal Charter 3.36/1640 that says that when you sign the retirement package that you've met all the requirements of that, whatever that rule is. And I just didn't know what those requirements were when you sign that application at that time. Does anybody know? I couldn't find anything. It's 3.36/1640.
We'll look it out, but I think if it's applicable within Mr. Gallagher, we were looking at meeting the criteria of the plan, all of the criteria for which they would be entitled to a retirement, the years of service, et cetera, and age. But we don't have that section in front of us, and it may behoove us to take a look and see if there's additional requirements that are assumed at the time that the application is signed.
Sure, and I can agree with Council Eaton May that the requirements there that you meet all the requirements for service retirement, meaning that you've met the requisite age and that you've met the requisite years of service. If it'd be helpful to review the application for retirement, I can certainly pull that up at the board's request.
Yeah, I would just like to know, because a lot of times with these applications, maybe there's something, and this might explain why there was no disclosure of any other information. Maybe it wasn't listed, or maybe it was listed. I just don't know.
Sure. So here's the application for retirement submitted to ORS by Mr. Gallagher. As you'll see here, it indicates which plan they're in, what retirement date they seek to be provided, the type of retirement. Here he had deferred vested because he had separated and later met the age requirement, and to retire, their information about the age. As you'll see here, the years of service, the two central requirements for service retirement, any sort of benefit information related to any survivors, other beneficiaries, dependents, spouses. This is the retirement application that is submitted. So to your point, whether felony conviction information is collected in the application, it was not one of the requirements of the retirement application at the time Mr. Gallagher retired.
Yeah, I understand that. there was some reference that you've met the requirements of 3.36/1640. And maybe it is just the plan. That's all. It wasn't meant to try to drill down. I didn't know what it explicitly said. That was all.
Sure, we don't have
and
that
because-
position currently up, but we can look
Okay.
into it.
I thought that might go to the issue of why it was never disclosed to begin with. And the other question I had is because this occurred before PEPRA, does that mean the inclusion of PEPRA considerations is also discretionary?
2 points. One, PEPRA does not govern this proceeding at all. There's a particular provision in PEPRA that clarifies that charter cities that have their own retirement plans organized under the city charters are not subject to PEPRA provisions. Regarding the timing of whether PEPRA was enacted at the time of Mr. Gallagher's retirement or not, or whether the board can consider it, it is within the board's discretion to consider PEPRA as and the provisions there, though it's not required to do so.
Oh, okay. All right. Thank you.
Yeah.
Those are
The only thing I was going to add is our position is because, like we talked about, there's no precedent. PEPRA where the state has visited this area in similar statutes, we believe it's instructional and certainly something the board should consider in looking at how it's going to apply this statute. You still have your discretion, but we look at it as instructional guidance.
Okay. Thank you. Thank you for the
I
answers.
actually kind of remember the answers. So I've been on this board now about 10 years, and PEPRA happened during when was it, Harvey? Like 2013. It happened right after I joined this board. Do you remember, guys?
It was effective January 1st of 2013.
Yeah, like first year after I joined the board. Yeah, thanks.
The board can look at it as analogous situations, but it does not govern the system at all.
Well, I think if I can jump in for Howard was also pointing out that it had not yet been born at the time all of this happened. He retired before PEPRA, right? Right. So, okay.
Yes.
Hey, the floor is actually, let's do this. Floor is open. Are there any follow-up questions from any of the trustees? Floor is open if you have one.
I have one.
Yeah, go jump in, Sunita.
Again, this is for Council Chin. I guess I'm a little confused about whether the board today needs to take into consideration that in 2010, when the board composed of different trustees at that time granted retirement benefits, didn't take this information. They didn't know about it, but they didn't take this information into consideration. Is that relevant to our consideration today as a fresh set of trustees?
Well, as far as I'm aware, and as far as the records for ORS have, as far as the records for ORS, excuse me, there was no information before the board regarding this felony conviction that was not presented to the board, and it was not within ORS's knowledge that this felony conviction occurred in 2010. The first time this Mr. Gallagher's felony conviction came to ORS's attention, and thus this board, was in 2021.
Okay, thank you.
If I can.
Yeah,
also,
jump in. Yeah.
I think it is relevant because irrespective of whether there's a new set of trustees that are sitting on the board is bound by the prior existing board's decisions. And so to the extent that the board made that decision, I think it is relevant to look at, when they made that decision and they granted it, was this information available? Our position, of course, is that it was common knowledge that there was ample information available. In fact, I think Mr. Gallagher indicates that the prior CEO was aware at the time that he retired. So I think it is relevant. How you use it, your counsel can advise you, but I do think it's relevant to take in consideration the length of time is one of the factors, and the decision that the board ratified the contract by approving the retirement allowance in 2010.
Any other questions
Yes,
from
Mr. Chair.
trustees?
Yeah.
You're going
Well,
to jump in, Dick.
I'm sorry, may I make one response
yeah,
to Council Eaton May's comment? So just to clarify, the board did not make a determination regarding Mr. Gallagher's felony conviction because it had no knowledge of it at the time it approved his service application in the record. Thank you. Sorry, Trustee.
So just to be clear, that's a bit like splitting hairs. What you're saying is, per Mr. Gallagher, I no reason to disbelieve him. There were members, there were trustees that knew, but they didn't bring it to the attention of the board, is what you're saying, Maytag. And those are different things, right?
Well, what Trustee Liccardo knew or did not know is,
Yeah.
you know, that it's not before this board. He is not here to
Right.
present, so I cannot attest based on that.
Yeah.
But I can say that this board has not considered whether Mr. Gallagher's felony conviction and its impact on his retirement benefits prior to today. The board has never made that determination.
Yeah. All right. Yeah, I looked through the minutes. I didn't see it. All right, board, so go ahead, Dick, you're up.
Well, that was going to be my question. And you guys are talking about that, the potential conflict of interest with Mayor Liccardo being a prosecutor and then as a council person. So that would be a question because later on, if it gets to constitutional issues, is that a conflict?
Right. The floor's still open. Oh, go ahead, Ms. Eat may jump in.
I do see that as a potential issue. And the records that we submitted shows his being involved in the prosecution as a DA and making the motion to approve the particular retirement allowance, granting of the retirement allowance. I do see that as, a potential issue that could come up.
Floor's still open. Any other questions?
This
Go ahead,
is,
Howard, jump in.
To go back to the information disclosure, who has the obligation to disclose or to uncover any information? Is it the member, or is it the board, or is it the city? Is the member obligated to disclose information?
So I can answer that, Trustee Lee. Under the San Jose Municipal Code provisions and the city charter, there is no disclosure obligation on the part of the member, and there's no reporting obligation from the city if it determines or learns of a felony conviction of one of our members. This is distinctly different from PEPRA. Under PEPRA, there's a specific provision there that requires the employer to obtain any information to report to the retirement board any felony conviction. And so that's the reporting and notice provision that's found in PEPRA that is absent here, which goes to explain in part how this board had a delayed discovery of this felony conviction.
Okay, thank you.
Any other questions from trustees? If not, let's close the floor on questions. And now, is there anyone from the public that wants to ask a question? Going once, going twice. All right, let's enter the second of three phases. Let's now make comments. And you can ask questions too, of course. And then the third phase will be, we'll see if somebody can untie this Gordian knot. So on this round, I've got like it's random numbers. Howard, you're up first, and then Andrew, Eshford, Dick, Dave, Franco, myself, and then Sunita. So Howard, more questions, comments? Jump in.
I guess my one thought I had was if this information were available in 2010, what would be different? And I really don't have the answer to that, but it's just sort of a comment. And then the question on the handbook to me, in terms of conduct off duty, is the conduct off duty in any way? Is there an expectation in any way in the handbook that it would have to be above a higher standard than say a city employee, or a higher standard than any other type of employee that's employed by the government. I guess those are my comments. And if there is some sort of standard that would be higher, then that might, I guess, have an influence on how you view the severity of the felony and so forth. Those are my initial comments right now.
Why don't we do this this time, sort of reverse? Ms. May and Ms. Tim, why don't you hold your questions until we go all the way around the trustees, because trustees may ping off each other. That's fair, okay, Ms. May?
Okay, that's fine.
Yeah, and then you guys can maybe sum up what we've said. Next in the list, Andrew, go ahead, comments or maybe questions.
Yeah, I got no additional questions right now. Thank you.
That is great. Eshfar, you're up.
No additional questions. I guess, I guess my comment is that I guess, we do have the discretion per the San Jose Charter, and I guess in terms of what we do, I think the fact that this was considered before, but it looks like there is no record that all the details and information were available, means that we need to consider this in making a decision.
Great. Thank you, Eshfar. Dick, any comments?
Yes. Years ago, being on this board, these issues were brought up but never took any procedure. And so it's pretty uncomfortable to wear a black robe and start making judgments. Some of the comments I have is that, our position was as fiduciary is to make sure people pay their premium and you provided them with benefits and investments. And now I see we're looking at other things. Do we let it on? Do we start looking at the serious felonies as murder, worse than something else? I don't know what's going to open up here. And do we go back to who submits what for potential back felonies that were committed? So there's a whole bunch of stuff that's going to be coming out of this that is very complex. I thought that the board handled those things in the past properly by just, even though it was on the books that I never heard of, but we just took business, and people earned their retirement, they got their retirement, and if people wanted to sue them later on for civil, that's what they did. So those are comments.
I'll make a humorous comment. So I'm sure you appreciate, Ms. May, that we read many pages, and there's almost in every month's deck an OSH blank blank moment. And when I read your thing and you said there are others that have committed felonies, that was my OSH blank blank moment. Not that we're aware of, and you may be pointing out that, as Dick just said, somebody just opened Pandora's box here. And I think this board is very aware of that we don't have the obligation to seek them out, but we probably have the obligation, once they're pointed out, to deal with them. And I'll address that in my comments when my time comes. Dave, over to you. Any comments? Any more questions?
Yeah, I think one of the things we're looking at that I'm struggling with is the time between retirement and now that when ORS is notified. I think we talked about it in the past when on one of the past board meetings, possibly having the associations, the bargaining units, and the people involved crafting some sort of guidelines that the city would be willing to accept that could help guide the retirement board in the applicability of this particular municipal code section. I do know that that is in process right now, and I wonder if we're not better off putting off a decision on these cases until we can have some sort of guidelines, or if it's or if that ship has sailed and we're just on pace for this today.
Yeah, that's really interesting. I hadn't thought about that. That's fine. Franco, you're up. Any comments? Any questions?
Yeah, I know I brought this up and Dave just talked about some of it. The reality is there probably are other people who've committed felonies in both of our organizations. This could be something that comes to us more frequently. We've had the conversation about Local 230 POA, and to the extent that they're at least involved in the conversation, the Retirees Association, their attorneys, including the city attorneys, coming up with, as Dave said, guidelines or guidance. I know that there was a request, and I could let Dave speak to that more, of potentially adding some of those guidelines to the Muni Code. So when this board did look at things, we would have a better criteria in which to make a decision. And that's not to say there's anything wrong with our attorneys. They're amazing.
And you too, Ms. May. We like you a lot too. I will go and then Sunita. So I sort of have an unusual badge on my chest. I probably have more experience with contracts than anybody here, including the attorneys. So as a VC with startups, not a week has gone by in the last 30 or 40 years I haven't written a contract. Every offer letter, I wrote many of them myself, is a contract. Every time we raise a round of money, it's a contract. I mean, I practically have a law degree in contracts. So you raised, my commentary is fine. You raised three, you really did a great job, Ms. May, because you really helped focus us down. You kept going to three things in your brief and in your oral stuff. Is this constitutional? Well, look, man, that's at a much higher pay grade, I think, than any board member here. And I think you have good points, and Council Chin has good points. You went to the point of prejudice. Well, I can tell you, until this past Sunday, I didn't know much about this. I knew there was something coming down the pipe of felony, but Roberto can tell you, we would meet monthly. I said, don't tell me anything. I didn't know the names. I didn't know the nature of the crimes. And I'll bet most of the trustees feel the same. I don't work for Mayor Liccardo, and he doesn't work for me. We really are independent. The city's pretty good about that. I can tell you from my standpoint as chairman, there's been zero talk about this, zero pressure put on. I can also tell you, and you're not going to want to hear this, Ms. Eaton May, every now and then, and in my 10 years here, it's happened twice with disabilities, somebody raises a red flag. We had a case we heard a year or two or three ago about somebody that we let off on disability, who then went on a TV show and did something very physical. And every time these get pointed out to us, it was the Ellen show, figure. Every time these get pointed out to us, like this one, we dig in and we followed that all the way to its logical conclusion. So I can tell you that, unfortunately, and that's why I had the OSH blank moment when you did that, when things get raised to us, we are a very professional board and we take it seriously. I think, unfortunately for you, Mr. Gallagher, your name was the one that was drawn out of the hat. But I can tell you that we're not treating him differently than we treat any other person that was called to our attention. Now, that doesn't mean we're going to decide to do anything about it, right? But we do follow through. So that's unfortunate. There is, I don't feel, you use the words public outrage and political purposes. Well, I don't feel the politics, and I'm not sure the public really is outraged. So I don't know about that, but here's the piece of the badge I wear. So we talk about contract. Me personally, Drew Lanza, not chairman, there is no doubt in my mind that Mr. Gallagher breached his contract. So let me take you through it. I've spent about 3 days looking into this. The International Association of Chiefs of Police, of which San Jose is a card-carrying member, says, unbecoming conduct. Officers shall not conduct themselves in a manner on or off duty that blah, blah. Okay, that's one. You go to the DOJ, and the DOJ looks for things that have a nexus to official duty. And the DOJ says, well, some things go beyond the nexus to official duty. And they talk about things off duty, and sexual misconduct is on their short list. Then you go to the oath that was taken to the Constitution. So I'm talking now about implied, right, contract. Well, the oath to the Constitution doesn't say on duty or off duty, just like our felony forfeiture law doesn't say on duty or off duty. Pepper says on duty or off duty, right? But I think that's a shift over time. I have been sworn in on more than one occasion against all enemies, foreign and domestic. One time it was to administer a wedding for one of my godchildren. I don't think they wanted me to take the oath for 30 minutes standing on a beautiful bluff looking out over the Pacific, right? I think they were saying during some period, you are an officer of the state. And while you're an officer of the state, you will defend the Constitution. I sure as hell don't think you're supposed to defend the Constitution while you're on duty and then plant bombs when you're off duty. I would also point out that in the very first section of the California Constitution, it guarantees people, the state guarantees people, of which Mr. Gallagher, I am now today an agent, right? Safety. It's in the second sentence of the Constitution. Those are now implied contracts, right? The National Association of Police, well, that doesn't apply. That's something voluntary. DOJ, well, we're not talking DOJ. California Constitution, well, we took an oath. It doesn't say on duty or off duty. So now let's get to explicit contract. Well, there was this thing in the San Jose Charter from way, way back that says our contract with you can be broken if you commit a felony. Doesn't say on duty or off duty. So that didn't break the contract, but your client, had he read the 37,000 pages, would have been aware of that. So I went surfing the internet. Man, I must have spent 5 hours on Monday. And I found what Dave and Franco know. I found you have to find the right terms. You keep searching for off duty. And I found in the police department duty manual, and I don't know if it applied in 2005 or 2000, but this is the code of conduct manual that Mr. Gallagher agreed to contractually, I would assume. And it says, I will keep my private life unsullied as an example to all. I give you 3 examples. Implied contract. We do implied contracts all the time. It's valid. It's been upheld in many courts. And 2 explicit things. So I got to tell you, Ms. Eaton, your defense of constitutionality makes perfect sense to me. It's way above my pay grade. I don't know. I can only speak personally that I feel no political influence or pressure. But your arguments that we are breaching the contract don't hold water with me. And you'll have a chance in just a minute to come at me on this. I think I'm 100% convinced Mr. Gallagher breached his contract with us. Now, whether we do anything about that is a whole nother question. But I'm personally assuming that that contract was breached, whether he was off duty or on duty. And I was pretty shocked to read Pepper saying you don't have to behave off duty. The hell kind of society do we live in when priests and teachers and even venture capitalists get to do whatever they want? Don't kid yourself. Pick up the newspaper. There's lots of VCs that have gotten in a lot of trouble doing stuff off hours, and they sully our whole industry. So sorry, I went on for long there. You'll have a chance. Sunita, any comments or more questions?
That was amazing, Chair, Chairman. How to go after that, but I guess I might say echo a little bit of what others have said. It is hard as a trustee to bear the responsibility to think of things like statute of limitations on things like this. But that's what we've been handed. It's a complicated issue. So I guess in my mind the thing that I'm that I was grappling with was, is it the politics that's influencing this new set of information coming to the board, or is that even relevant? And so where I came out with this is that it's a new piece of information. What the source was is irrelevant. The decision we're making should not be politically biased. And so I'm separating the two. Whether it should have been there before or not is not relevant. It is now. And so it's a material piece of information to make the decision as a trustee today. So that's sort of where I would.
Yeah, I think your comment directly goes with what Franco and Dave are saying, which is, so yes, that's true. And now there may be a freight train of 7 more coming our way, right? And do we treat them all the same? If this is something, Ms. Eden May is right. It's never happened, Ms. Chin's right. It's never happened before. I've been on this board for almost as long as Dick has. And in that entire time, we've only seen 2 cases of people we thought might be faking disability. We've never seen this before. And I say it's the OSH moment, Ms. May, when you're saying, yeah, there's a freight train coming your way. All right, enough comments. Ms. May, how about you first? Just jump in. Anything you want to say or anything you want to ask us, go ahead.
Okay, you hear me? Am I audible?
No, you're good.
Okay. So I think in response to I believe it was Howard's comment, where he talked about whether the information was available in 2010, and I think there was some discussion of who should supply that information. I think that's the whole point. There's no guidelines set up here to find out. We're going to say it was common knowledge. Whenever a law enforcement officer is convicted of a crime, especially a felony, the police department jumps on it. Now, why didn't the, pension plan didn't either find out about it? We believe that there were people that did know about it. It just didn't come up. There's nothing, no mechanism that's in place to enforce this particular provision as it is in PEPRA. That's why they put it in PEPRA. They put the onus on the employer to notify the plan. Something needs to be done to prevent you from having to face this decision 10 or 12 years later after you've already decided to grant the pension. And so that's my concern in terms of there's no mechanism. What's the criteria? How do you determine who's supposed to do it? Nothing's there. So I think if you had those guidelines in effect or something in effect at the time, the board would have looked at the time that a law enforcement officer makes an application and do the screening, or the employer would have the duty to report. Here, there's nothing, and that's what makes it so, hard and difficult and unfair in the sense that this person, even though this code was on the book, there was nothing to indicate that there was even a possibility this was going to be enforced, because it's never been enforced before. It's never been adhered to. It's never been pushed. And I think to do it now, our position is to do it now would work a tremendous hardship on individuals who are now in their 60s, who have no choice to try and find other types of income of which they rely. I think there were several comments made, but I always wanted to go to the chair's comment.
You're fading out again.
Okay, can you hear me now?
No, move a little to your left.
How's that?
That's better.
Okay, co-reporter, can you hear me? Okay, good. So I'm going to go to the chair's comment. I think that where the confusion a lot of times occurs is when a law enforcement officer engages in misconduct. Now, just kind of couch my concerns by my background. I was a prosecutor with the Attorney General's office for almost 15 years. And so when a law enforcement officer engages in misconduct off duty, it's looked at in an employment context. In other words, that officer is probably not going to be of value to the prosecutor, because if you put them on the stand and they've been convicted of a crime, their credibility is probably not very high. The jury is not going to. However, with respect to retirement issues, it's a different type of arrangement. You're earning that contract and that salary and compensation during your years of service, okay? And those years of service are only counted when you're on duty, not when you're off duty. And so your years of service, what you're being paid for, the promise to pay you in the future, is for working during those periods of time that meets the plan requirements. And because it is a constitutional right for public employees, before it's taken away, there needs to be some criteria. And that's how PEPRA came about, by saying, and some of the decisions came about, because when it got to the court was saying, well, we're not talking about an employment situation here. We're talking about a promise to pay. And so how do we get out of that promise to pay that the service has already been rendered to make it constitutionally legal? And that's where we're saying those cases are guidance. And if you look at that guidance, you would not conclude that Gallagher breached the contract. Now, did he violate terms that makes him ineligible for employment as a police officer? Probably. But did he do anything that would preclude him from getting the benefit of his bargain that he served, that he earned? To lose that at this time, under the guidance that we have now, our position is he did not breach that contract. And all we're saying is, take a look at that. That's going to be the parameters that if we have to have a court look at these situations as this train is coming down towards you guys, I think those are the criteria the court's going to look at. Of course, it's going to consider the discretion and the language in your provisions, your code, municipal code, and your charter. But I think in reviewing it, it's going to be colored by some of the information that's there, that's been put there to give some kind of structure and not allow a board this unfettered discretion to sit as a judge and put on a black robe to decide who gets it, who doesn't, who breached, who did not. And so our position, and we're encouraging you to just see those as your instructional guide as to whether there has actually been a breach of contract under the law. Despite the fact that those provisions are there, another factor is you never enforce them. Nothing's never happened. When was a retiree to challenge it if they haven't been applied? They've never been aggrieved by that. And so I respectfully disagree with Chair in terms of that breach analysis. I think most of the other comments, were valid, and certain things that you have a large order in front of you, and I think I've done my best to present the issues from Mr. Gallagher's perspective so that you can weigh that in making your determination. Thank you.
Thank you. Maytag, you want to weigh in?
Yes, I have a few brief comments in response to Council Eaton May's closing. And before the board takes any motion or goes to further deliberation, I also would like to do a few administrative things for the record. First, in regards to the board's discretion, it is not unfettered. It's guided by the parameters set by the San Jose Municipal Code and the city charter, as well as existing case law, as the materials to the board in Exhibit A that the Plans Council provided to you outlines. Regarding the employment contract, as Council Eaton May had started her presentation, the employment contract guarantees the member compensation in two forms: one, salary, and two, deferred compensation in the form of retirement benefits. And so for her to now say that retirement benefits are not a part of the employment contract is at odds with what she began her presentation with. One thing that I want to mention for the board, it's been referenced a number of times, and I understand Ms. Eaton May's objection to the document, though I do believe that it is the best source of information for the document to be shown to the board, given its various references and comments and being read from the document. So I will now go ahead and share my screen, subject to Ms. Eaton May's objection.
Thank you. The objection on the record.
Yep. Yeah, we got it.
So here, if you guys can see it, is the San Jose Police Department's duty manual. And if you look at page 62 of the manual, you'll see here Law Enforcement Code of ethics. Within that, it states, I will keep my private life unsullied as an example to all. And it further states, in honest thought and deed in both my personal and official life, I will be exemplary in obeying the laws of the land and the regulations of my department. And so just to put a finer point on it, this does impose a duty on all sworn officers to maintain lawful conduct in their private life as well as in their on-duty service. So that does impose a slightly higher standard for police officers than it does for any other civil servant. With that, I do want to close with a few administrative things just for the transcript. I would like to attach as exhibits all materials that have been presented to the board. As Exhibit A, I would like to attach, and I will send to the court reporter with the agreement of Ms. Eaton May, as Exhibit A, the plans, memo, and exhibits attached thereto, submitted to the board. As Exhibit B, I would like to attach and submit with the transcript the opening brief and exhibits provided by member Stephen Gallagher's counsel that were provided to the board. And I would like to attach as Exhibit C the PowerPoint presentation that Ms. Eaton May has presented to the board at this in this meeting. And lastly, I would like to attach as Exhibit D the duty manual for the San Jose Police Department. And I will send these to the court reporter following this meeting.
Okay.
Go ahead, Miss Eaton May. Floor's open. Go ahead, whatever you need.
Okay, thank you. I want to make sure I'm in the right spot. Court reporter, can you hear me? And so I think we assumed with the transcript that the exchange of information that Ms. Chen has identified as Exhibit A and B would be part of the record and would be with the transcript. With respect to Exhibit C, I did not intend to have that as part of the board record, but I have no objection to that. On Exhibit D, I think there is a problem. My client has not, there's no evidence that my client signed that or was a part of that. We haven't had a chance to look at it. This is the first time we're seeing it. And so I, would object to that being able to be a part of the record. Oh, one more thing. Sorry about that. When I was discussing with you the analysis with respect to off-duty conduct for law enforcement officers, I wasn't saying that the compensation wasn't part of the contract. I'm saying that the analysis that you utilize when you're looking at it from an employment context as opposed to a pension context is different. And that's exactly what I was trying to convey, that, the parameters around looking at when you can forfeit, cancel, terminate a pension is much different than when you're looking at whether an employee has engaged in conduct that's a violation of the particular rules, subject to disciplinary action, whether they undermine their ability to be effective as an officer. To me, that's different. Analysis, same contract, same terms, different analysis. That's all I was trying to convey. Thank you.
Thank you. Yeah. Oh, and you can correct the typo before you send the deck over. How about that?
Okay, probably some others too.
Maytag, anything from you? Are we sort of good here?
No, her objections noted on the record with regard to Exhibit D, but Exhibit D will be attached to the transcript.
Okay. So I don't know about the rest of you, but I need 10 or 15 minutes to gather my thoughts before we really make a motion or debate. I am showing 11:11. Why don't we take a break until 11? Is that right? Is it that late? Oh my God. 11:25. Let's take a break until 11:25. So I was thinking on the break, there really are two decisions here. And the second one's predicated on the first. And the first decision here, and I think Mazit may sort of sum this up, is are we going to do anything? And we have the right to do something really tiny or something really big, or are we going to do nothing? And so if I can take a straw poll of the board to see, do you think we should do nothing? Or do you think we should do something? And something could be really small, it could be really big, to be decided if you think we should do something. So the order for this third round, as determined by a random number generator, is Dave, then me, then Eshvar, then Franco, then Dick, then Howard, then Sunita, then Andrew. So the only question is really, do you think we should do nothing? Or do you think we should do something? And we'll figure out what something is later. So Dave, do you think we should do nothing or do you think we should do something?
Yeah, I'm going to kind of answer both of them. I think we should do something. I just think we need to defer until we hear from the bargaining units on what they believe the criteria should be for implicating and actually applying this municipal code.
Okay, I'm next. I think we should do something, although my inclination is something small. Eshvar, do you think we should do something or nothing?
For some reason, my video is not working, but I think we should do something. I think, I think people have talked about the risk that this is just going to start an avalanche of, other claims, I guess. I don't know if that is true. I don't know if we have any information that says that there are a lot of felonies which have not been dealt with. The second is this, even if that is the case, this may be the standard where if you don't do anything here, can we do anything in the future, right? And do we just say that we don't do anything at all? So on that measure, I would say we should do something.
Okay.
I'm going to disconnect and come back, Drew, just to...
Oh, great. Yeah, you're fine, Eshrar. Just be going down the list. Dick, do you think we should do something maybe small, or do you think we should do nothing here?
Did you say me, Drew? I didn't hear you.
Yeah, Dick, I'm sorry. Yeah, you.
Yeah, let me make a comment. When we're talking about, and again, things bother me when you're supposedly wearing a black robe. Just does not resonate with me at all, because it's like double jeopardy. But I also consider, what about the victim? What about restitution? So something should be done. Yes.
Franco, something or nothing?
I'm along the same lines with Dave. Something should probably be done, but I want some guidelines that are vetted out through all the involved parties, so we have a better understanding of what we're looking at.
So Howard, do you think we should do something or nothing?
I'm in general agreement. I think we should do something only because I think if you do nothing, then you may actually start to set a precedent for other things. So I think it's worth to do something.
Sunita, do you think we should do something or nothing?
I just want to make sure I understand your question when you say do nothing. When you say do nothing, it basically say that there is no change in Mr. Gallagher's benefits. Is that your question?
Yeah, I mean, we have to make a decision. Our decision could be status quo. That's what I mean by nothing. Yeah.
Okay. I mean, I think I'm veering towards the consensus, which is that I think we are obligated to do something, and it just we have to think through what precedent it sets, and it feels a little rushed to be able to do that at this point.
Yeah. Okay, then last but not least, Andrew, do you think we should do something or nothing?
Yeah, I'm with consensus. I believe that we should be doing something.
All right. Well, good news, board. At least we're unanimous. We should do something. So, Maytag and jump in, Mazit, man, Harvey. So Franco and Dave are saying, can we delay until we get more clarity? Is that an option we can take?
Yeah, I can take that on. So
Yeah.
the laws at the time that were on the books, in any standards or guidelines at the time Mr. Gallagher retired in 2010 are the governing laws and guidelines. Now, if the unions in the city subsequently after he retired come up with guidelines, those guidelines do not govern his case. What is governing to our case is the existing case law and the text of the San Jose Municipal Charter and the San Jose Municipal Code.
Harvey, Ms. Eaton May, do you have any thoughts on what Councilor Chin just said?
Yes, I think that we talked exhaustively here about the fact that there's no guidelines and trying to make a decision without some kind of parameters based on the language in your particular code and section, I think will lead to trouble. It will definitely get you down a line where you're going to be in litigation for a long time. So I am not aware of anything that does not give you the authority to defer your decision on this particular matter until a time in which you feel you have sufficient information, sufficient guidance, sufficient direction on how you want to proceed and what you want to do at that time. I know that's probably difficult for my client because then they have to continue to live on this suspense of what's going to happen in with my life, with my income. But in terms of your authority to defer a decision until some later time and take any additional information, that would also be, maybe comments on any kind of guidelines or anything like that. I'm not aware of anything that would preclude you from doing that.
Mr.
So
Chairman.
Harvey, for me?
Can you hear me okay?
You're just fine. Thanks, Harvey.
Great, thanks. So Ms. Chin was correct. Any change in the law, and Ms. Eaton May has even raised this with regard to the matters that she was arguing this morning. Any change in the law after somebody retires can't be applied to them. So while it might make sense for people in the future to have some guidelines, if you will, placed in the text of the law itself, we could not apply those changes to these gentlemen who you're considering today. But I would want to make this comment. The board is not without guidelines. We have spent a tremendous amount of time and energy providing some guidelines to the board that exist in the law and that exist in the analogous law under PEPRA. It's not an unfettered discretion. You have to go by some book that has 3 or 4 specific provisions that you check boxes off on. It's not structured that way, but it's not as if the board has no guidance whatsoever. We've provided substantial legal guidance to the board to help educate you on what the chalk lines are in the law and where you could exercise your judgment. So I do respect the collective bargaining process. Whatever comes up through that process, however, can affect future retirees, but not people who retired under the law that exists at the time they retired. So postponing this for collective bargaining to continue to take place would not assist the board in making decisions in these cases.
So Franco, Dave, you want to debate that point with Harvey or Maytag?
Yeah, it's Franco. I'll start it. I'm not talking we're talking about 2 different things. Changing the municipal code later down the line is one thing, but getting a feel from the associations as to, is it got to be a violent felony or is it going to stick with any felony? If someone is 73 years old and they have dementia or Alzheimer and then a care facility, we're going to take that pension from him. So he's out of that care facility and now, a board of the state. I mean, there's so many different criteria that apply to this. So I'm just talking about them saying, look, we all came to agreement. Yeah, we're going to do something, or you're going to do something, but these are some parameters that we think are reasonable as to when you would. And I don't think that's any different than what we're looking at now. It's a lot of the things that you've mentioned. We could use some of the pepper stuff, or we don't have to because we're not bound by it. We could consider a timeline, but we're not bound by it. That's all I'm talking about.
So do you have any idea, Franco, when you guys might have sort of a draft list of those things?
I'll defer that one to Dave.
Dave, any idea?
Yeah, I don't have an exact timeline. I do know the outline that the POA came up with is currently with their counsel. And once he signs off on it and legalizes language, puts it into lawyer speak as word, then we're going to share it with, or the POA is going to share it with Local 230 and then the Retirees Association. But as to a definitive timeline, I'd say probably within a month might be fair. But it could take longer because once the two bargaining associations agree, then it has to go to the city. And then we have to talk with city attorneys and who knows how long that takes.
So why, board, you guys like me, I've been here for 10 years. I think I can make a motion. It's a kind of a screwy motion, if you'll let me. I know it's kind of board's chair's prerogative. So to me, it seems like we have to sort of square four things to make the circle. And Franco and Dave just said one of the things we want to try to square. The second thing we want to try to square, and I think we have squared it, and we got this from all sides, is to be fair. I mean, Maytag's been banging that drum now for months. Due process, you got to be fair, you got to be good guidelines. So we got to square that. I do think there's some damage done. Look, Black Lives Matter sullied policemen, whether rightly, wrongly, fairly or not. By most estimates, it caused over $2 billion in damage, and some of that to city buildings, federal buildings, state buildings. So the reputation of police matters, and upholding that reputation matters. Now, we may disagree, and I agree with you, very friendly, Ms. May, of whether there was or wasn't a breach of contract, but it's a debate. Just like you say, it's a debate, is it constitutional or not? There are real debates here. The final thing is, and here's why the motion's gonna be screwy. God, I don't want to touch Mr. Gallagher's pension payments. He said it well too. I mean, Jesus, we've been paying them this for over 10 years. So my idea comes from my world, VC. So this is civil, this is damages. How about we let Harvey and Maytag negotiate with Ms. Eaton May and Mr. Gallagher to figure out what's something. And I looked in my ancient history textbooks, and off the top of my head, and I wouldn't be directing Harvey or Maytag or Ms. Eaton May, there's this notion of a tithe. You know it through the Bible, but it goes way back thousands of years before to Babylon and Mesopotamia. And there is this kind of notion that maybe Mr. Gallagher, we might impose upon Mr. Gallagher, here's your pension check, we haven't touched it, but we will touch it unless you tithe some portion of your money to a civic program for youth. So here's a screwy motion, I wrote it down. And you guys feel free to shoot holes in this, but here's a screw motion. I move that the board not reduce or eliminate any portion of Mr. Gallagher's retirement allowance, provided Mr. Gallagher signs a contract that he will donate some small percent of his pension to be decided in negotiations with our attorneys and his, until his death, to a charitable or civic program to be decided by negotiation, designed to assist underage youth in the city of San Jose. And the details of all this are to be worked out through council and approved by this board at our August board meeting and with luck, Franco and Dave, if you push your buttons hard, you get input into that process.
Mr. Chair, Santos, second with discussion.
Yeah, okay, so floor's open. Feel free to tell me that's stupid and screwy, but
Mr. Chair, I just said
Yeah.
I second that in the comment. That could include restitution to the victim. So what I'm saying, I think that's a good discussion because we have done that with overpayment and underpayment. We have done things about finances. We also had a person,
Right.
as you know, a couple of years ago, over their wife's death, didn't pay certain premiums, and so we have done things like that. I second that motion. I think it's a good start.
So Dick, do you want me to amend the motion to say it could be a civic youth program or restitution to the victim, or?
I think we should keep that open, sir.
Okay, so the seconder has suggested a change to the motion. The maker will add or restitution to the victim on your plate of what you can negotiate, Maytack and Ms. Eat May. Dick, do you agree to that change?
That's
to the
my
motion?
second. Yes, sir.
May I make
So-
a comment?
Jump in, Maytack. Floor is now open. Feel free to take shots.
Sure.
Yeah.
What on the comment on restitution, it is unclear to me whether or not Mr. Gallagher has fully met that obligation in the criminal proceeding or not. I do think that is a criminal matter. I would prefer to keep the criminal aspect of it out of it with
Okay.
regards to the victim, because it's unclear whether or not he's already met restitution.
So it's on your plate, Maytack, for you to come back and say, you know, guys, no restitution. It doesn't make sense. But the motion grants you that power. Is that too screwy, Ms. Eaton May, or does that make sense to you?
Well, I think it has some attractiveness in the sense that it, allows my client to sort of keep his pension. I probably would have to work with Harvey and Maytack about the logistics of how it would work. That would probably be the main concern. Like I said, I did about 20-something years of public service, and sometimes you're not able to use private money to fund public programs, and
Yeah.
I think there's a lot of logistics that would Mr. Liederman and Ms. Chen and I would kind of have to figure out to make it work. And I just haven't done the research on, whether a person can donate as maybe a charitable deduction to someone else as an obligation or condition of keeping their pension. I just don't know. I don't know if Maytag or Harvey has any research on that.
For my world, contract law is the Wild West. So I can imagine writing that into a contract for, say, a 401k. Well, let me tell you,
Mr. Chairman.
let me just jump in. I've been very impressed with your intellect. I'd love to be a fly on the wall if this motion passes. You and Harvey and Maytack going at it, because you are all three real smart folks. Go, yes, Harvey, jump in.
Yeah, thanks. I'm wondering whether the motion contemplates what will happen in the event that an agreement along these lines is not prepared for the board's approval at the August meeting. Does that mean the board is a maker of the motion and the second intend that if we can't reach agreement by the August meeting to present to the board,
Good
that
point.
the board will then reconsider the matter? Is that part of the motion?
Well, what do you think, Harvey and Maytack? I mean, really, the onus is on you. What do you think?
Sure. I agree with Harvey on this. So with regard to the motion as it's been teed up, it essentially forms a settlement agreement where the board agrees not to cancel or terminate in exchange for an agreement to provide a certain donation to a specified charity. That's an agreement that the member and the board may certainly enter into. Harvey does raise a good point that if that agreement does not consummate, then we shall reserve the right. We should reserve the right to revisit the matter at a later date.
I think that's correct, and I said provided, so I think the motion I actually got my thesaurus. I have to choose that word carefully, right? So floor's open. Andrew, Franco, Dave, is this screwy or does this make sense?
This is Dave. I will say, well, it's different. It's not something I thought of, although when it comes to disciplinary actions within the department, which is my only point of reference on this, we do settlement agreements all the time. So I could see as where that'd be applicable, and the damages would still be awarded in the fact that his pension would be reduced by a negotiated amount. The other thing I would probably add to that is put a time limit on negotiations so that it's not unduly drawn out for a long period of time.
Well, that's why I said August. The reason I kind of like this idea is because I'm listening to you, Franco and Dave, and this way you guys, we're not deciding today. You guys get a bite of the apple by talking to Harvey and Maytack and giving them your input as to what you guys are essentially doing is predicting the future. And I would think if I was Harvey and Maytack and Ms. Eaton, I would want to know what that future is. As Harvey says, it is not determinative, but it is input, right, Harvey? Oh, you're on mute, Harvey.
It would be input.
It would be input. Franco, is this crazy, Andrew?
This is Andrew.
Yeah.
No, I feel comfortable, with this approach. Having basically both parties that can come to some type of settlement. If we find out legality-wise that we're not able to do contributions to to an organization or something like that, it's basically in the sense that if they deduct to contribute to an organization, but we can't do that, we could just deduct this paycheck then that same amount. The dollar at the bottom line is going to be the same. It's just we're trying to do a good cause at the same time.
Yeah, and I would say, Mr. Gallagher, two things. One is if there is some small percentage of your check you donate, you do get that as a tax deduction, so you will get some amount of money back. It would be less if you donated it than if we did. And I would also say, Mr. Gallagher, I listened carefully to what you said, and this board doesn't have the capacity to really work with you and understand your hardships. But I'm guessing our council and your council and you can really sit down over a long day and sort through that. And I was listening to you, and you and I are probably about the same age, so I get it. Eshwar, I saw you wanted to weigh in.
Yeah, I think what Andrew said about I guess the other approach is you reduce the amount of the pension. And I was going to ask the question, we reach an agreement, and what happens if there's a breach of the agreement in the future where those donations are not being made? Does it come back to the board? And how do we deal with that?
Yeah, I mean, I would look for both councils to sort that out, right, Maytag?
Yeah, so any sort of breach provisions to the agreement can be included as a remedy in the settlement agreement, and that's something we may consider in negotiations.
Yeah. Franco, is it wacky or does it work for you?
It's wacky, but it works.
Next beer's on you, Franco. Anybody else? Floor is open. Maybe go around and take a vote.
Dave Wilson has his hand up.
Yeah. I'm sorry.
Dave again.
Oh, Dave, jump in anytime you want, Dave.
Just more of a technical question on how it could work. Maybe for Roberto to answer. Is there any way that whatever deduction is agreed upon could be taken out on the retirement side and then paid directly, so that we don't have to worry about an oversight on whether or not the payments are actually being made?
So anything can be done, Dave. My preference is that it's not done that way. You don't want to hear what I think about the whole discussion, but the bottom line here is, the bottom line here is, I think it would be easier, and I think that's not your point. Your point is that you'd rather not do that. If we leave it to the member to make the donation directly, and of course, I think that he will need to provide us with supporting documentation every year that donation is being done, right? So that we can make sure that that's happening. Because this is my concern. I think we could send a check to some charitable organization that is designed in a contract. But as you mentioned, if we do have more cases in the future, I really do not, I would prefer not to put the staff in a position to keep track of charitable organizations related to specific conventions where they have to be making checks out of 7, 10, 12 members. So I just don't want to open that door. If that's what we have to do, we will stand ready to get it done. But my preference will be that we do not. Did I answer your question?
Yeah, you did. You said it's possible, but we don't want to do it. It would be easier if they did it. That's what I was looking for.
One of the four things I was trying to square the circle is I desperately don't want to touch pension payments from us to the retiree. I'd much rather do a side deal. You had your hand up. Jump in, Sunita.
Yeah, I mean, I guess if I were to apply what I heard earlier from others and myself, that we don't want to set a precedent, or we want to think through the implications of a precedent. I'm not sure this motion necessarily allows us to do that. I like the principle that there is we are taking action, and it's from a fairness perspective, it seems very balanced. But I do worry about the unintended consequences of every future action where we have a settlement and then there's to be a monitoring process, whether it actually happens, and also creating an incentive for the rest of the pension retirees. I'm just thinking aloud here. So I just worry about it.
Yeah, I think of that, but I thought of that, actually, that was my biggest concern when I was offline working on this. But I think that's what Franco and Dave are trying to do in the background, is give us guardrails. And with any luck, they will feed that into Maytag, Harvey, and Mazit May in June or July. So whatever settlement we come up with might sit within the guardrails that all future settlements will come up with. Although it may be that future settlements are done in civic settlements and not, I desperately don't want to touch pension payments. Maybe I'm wrong, but I just feel like it's an electrified rail. I don't want to.
Mr. Chair,
Yeah.
They've done enough payments to ex-wives and you name it to last a lifetime. So, let's get back to square one. Look at reality. This is an organization. You're being the most fairest man I can understand right now. This is a great way to solve this issue and set the precedent.
Chair Lanza, I just want to reiterate the point that Harvey and I made earlier. Any guidelines that may come out of this negotiation, while we understand it may come from the unions, will also require input from the city. Those guidelines are input, but are not controlling in any way. We understand that the act is subject to meet and confer negotiations for members moving forward. Now, this is a member that is coming before those guidelines were issued. So while we may receive them, they do not govern our settlement negotiations.
No, well said. And for the record, again, the maker of the motion didn't intend that to happen. It is input. We are, it's that classic Maytag. We sort of got 2 or 3 things going on in parallel. Helpful if parallel tracks talk to each other. Don't have to do it. They're in parallel. They're not linked yet. Floor still open. Any other comments?
Mr. Chair, I'm not involved or will not be involved in the negotiations. That's up to council and obviously our member and his attorney. And I venture to say that when you made your comments, everybody had a sense of what you meant by a small portion. And I don't want to step on anybody's toes here, but if I was the one to be negotiating, I would ask the board to give me some, for lack of a better word, guidelines, right? Because a small portion to you may look different to council. I'm not suggesting that that's the case. But the last thing that I would like was council to work very hard on an agreement to come back and the board almost unanimously will say, gee, that's not what we were thinking about small. Or vice versa. I don't know. Maybe it's not important. Maybe council is comfortable.
I did mention that. I really did look in the history books. A tithe was always a small enough number that the farmer wouldn't die, but a big enough number that it was counted. So historically in ancient Mesopotamia, it started at about 10%, but it could be anywhere from 5% to 20 historically. So somewhere in the high single digits or low double digits. That's me, and maybe others agree or disagree. Maybe Harvey, you guys can come back at our June meeting and tell us what's forming up. Maybe you're welcome to come anytime, as he may too. Does that make sense, Harvey? Is that enough guidance for you guys to move forward?
Well, I guess I was going to say, hoping you can hear me.
Yeah.
There's probably a lot of legal issues that Harvey and Ms. Chin and I have to look at if you decide if this motion passes.
Yeah.
And one of them will be certainly part of an attorney's duty is when we're negotiating, if there are terms on the floor or terms exchanged, go back to our client and get approval.
Yeah.
So if in part of our negotiations, we say 3% is as far as we're going to go, or 28% is what you're going to do, we'll have an opportunity, usually, council will confer with you before the deal is final, so to speak.
Yeah, I agree.
Also, I think the legal issue of whether you can touch a pension, a person's pension after it's been issued to give it to charity, and how that, I just think there's more that we need to look at on that particular level as we are in negotiations. And I plan to do my homework and research and share it with Harvey and Maytag, and I know they'll do the same. And we'll make sure that we have an agreement that is tight if this motion passes.
Right.
Yeah, and I do piggyback on Ms. Eden May's comments. One thing I do want to, I understand that the board's motion is for the member to contribute a portion to a particular charity subject to negotiations. Whatever portion we negotiate, I think should take into consideration hardships and other equitable considerations that we may need to address that's fact specific. So I do not believe that having a specified amount as a settlement authority as a part of the motion would do us justice there.
No, I was only reading the sentiment when we were in the room for something. I wasn't sensing a hammer, I was sensing a feather, and I think you probably sensed that too. So something, go jump in, Howard.
Yeah, thank you for all the thoughtful comments. Drew, thank you for the framework. I agree, doing contracts and deals gives you the idea of just settling. And I think that makes a lot of sense here, because we can't go backwards and look at 2010 and act as if we were there. And I think something has to be done in this case, because it's the first time, I guess, at least as far as I could tell. And I think it's important that we do something that's both constructive. It sends a signal about how this is approached for the future, and also ultimately, I think it should take care of the members. Those members that are working today, that are retired, as well as Mr. Gallagher. I think it would be extremely unfair to sort of hand out a punishment that would have occurred in 2010 at this point in time. So I think there's some work to be done with the negotiation, but I support it.
Great. Floor's still open. More comments? Going once.
And
jump in.
So Drew, just make sure I understand the motion. It is to let Maytag and the two councils figure out what that amount will be, or is the board going to weigh in on what that amount is going to be? I'm a little confused.
I think Ms. May said it right. The chair is giving guidance. It's a small number, and nobody's really objected to that. So high single digits, low double digits, and the charity to be picked, and then working with Roberto, the mechanism to be decided. Per Howard, having done this forever, the rule of thumb is, and I think Ms. May alluded to this, is to give the councils very broad latitude and very general high-level direction, because they got to hammer down. So, right, so you don't want to take half his pension check, I assume. I mean, so everybody said something, but they didn't say, let's kill them, let's hammer them. I didn't hear that.
Well,
So I read that as a tithe. Historically, a small number is 10%.
yeah, I mean, I thought the something was more the principle that we want to, whether we want to reduce it as opposed to the number, but I don't know. I don't know what the other trustees feel.
Just ask a question here, Drew. I don't know, Maytag or Harvey, are there no other examples where something similar happened? I guess it's a felony, and I would say not a light felony. It's a serious felony in my view. And how maybe a pension board, which had the discretion to make a judgment on this, how they acted.
Sure. If we're going to use PEPRA as a guidance, if in cases that have been litigated under PEPRA, the forfeited period or forfeited amount is measured along with the years of service that are covered from the felonious conduct for which it was committed. So the first earliest date of the commission of the felony that was convicted through the conviction date. So every year in between is a forfeiture period, and any service credits that were accumulated during that forfeiture period are then subtracted from the members' calculation of their benefit. And so that is one way to do it, and that's how PEPRA has done it. That's not the San Jose Municipal Code provision here says any or all. It does not have that specific metric.
Let me add some color to that also. We don't have good precedent for how a board acts in these circumstances, because the most recent precedents that we have, both under the judge's retirement system, the case I handled for CalPERS against the judge in Santa Clara County, and the PEPRA cases that our office has handled and ones that we haven't handled, are all those decisions are all required by the statute. The board didn't have to exercise any judgment as to how much or under what circumstances to do it. The statutes said if A, B, and C tests are met, then the board shall eliminate the benefit for a specific period of time or in a specific amount. So there is very little to go on in terms of a board having the full judgment call, where our statute, our municipal code says the board may do something. So it's hard to look at what other boards have done, because the other boards have done it by the numbers, and the numbers were dictated by the legislature. We don't have a checklist of numbers dictated by the city. We have a discretionary grant that says we may do something, but we're not obligated to do something.
So can I follow up and ask you, so in those cases where it's mandated what the board should do, how does it compare with what our discussion is right now?
Well, in the Judge Dancer situation, the judge's retirement system said that he loses his entire benefit. So the judge was stripped of his entire, many years after the fact, stripped of his entire retirement benefit. In the PEPRA cases, the measure of how much is forfeited is the period of service. You basically, if somebody worked 25 years and they were convicted for committing a felony over a 5-year period, they would lose 5 years of service credit, and that would automatically reduce their benefit by that proportion of their total service. And they would also then, under that law, get back the contributions they made during that period. So it's all by the numbers. But the consequences in those cases under those laws are much more severe than this board is telegraphing in this motion and in your prior comments. the severity that I'm hearing from this board is not anywhere near the severity of deprivation or forfeit that is imposed by the other statutes. In the Wilmot case, for example, that we had in Contra Costa County, the firefighter who was stealing from the firehouse, those acts of theft, which created the felony he was convicted for, took place over 12 years. So he lost 12 years of service credit out of his total career, and that reduced his benefit almost in half. So there's kind of a comparison of what this board is talking about relative to what's happened in other cases. But in the other cases, the board didn't have a choice. It had to follow and do it by the numbers.
Okay.
Can I
More
jump in,
questions?
Ishwar?
Yeah,
Yeah.
don't-
Go
I mean,
ahead.
the floor's open. Jump in.
Yeah, so
We-
I mean, I guess there are two things here.
Reporter's going to shoot me. Hang on, you go first.
Yeah,
would
I
be a
think the
felony.
discomfort is when we started this conversation, it was either do nothing or do something. We never talked about do something, didn't talk about 0 or 100% or 1% to 100%. And I think that's my discomfort. The second consideration, which I hear from Dave and Franco, which really resonates, is the bargaining units and what guidance they might give us. That will probably help us benchmark what this number should be. I guess I'm personally uncomfortable with the motion to be that vague at this point.
Yeah, Ashfar, go ahead.
Yeah, I mean, I guess I'm just thinking about what Harvey said that I guess maybe the board is going too easy relative to what some of the comparisons are. Should we, I guess defer to the next board meeting, so we can all kind of form judgments, because I guess it's something very new. We have not dealt with this before, and I mean, you did talk. There was a breach of trust, and question is, what is the penalty we should impose? It's something we've not dealt with before, so that's what makes me a little uncomfortable whether we rush into judgment. But ultimately, I'll defer to you, Drew.
And that's a good point, Ashfar. If we delay this till next month, we also get a chance to see the second case, which is inclement, right about here. Harvey, Maytac, should we delay a month? What you're thinking?
Well, here's my take on it. The motion as it stands instructs the council between the two parties to see if we can reach a settlement agreement on what we're going to do with the application of the statute to the members' retirement benefits. And if that settlement negotiation falls through, that the board reserves the right to revisit and determine how it will apply the statute. And so it's kind of a two-part alternative motion where it allows the council and the member to reach an agreement if we can, and present that to the board with the members' agreement. And if we are not able to make that agreement, then the board will then reconsider and determine what percentage and how it will make that metric. Harvey, do you have anything to add?
And Mr. Chairman, I'm going to make a recommendation.
Yeah, please do.
And my recommendation would be that the board not vote on this motion at this time, that it be tabled until our next meeting in June. It's a lot to ask the board. The board has had to digest a great deal. When we make actuarial determinations, we do them over 2 board meetings to give the board an opportunity to consider those serious consequences. In the interim, between now and June, we as your council will have a dialogue with the members' council and see whether there isn't a settlement agreement to be had they've listened to the board members' comments. They've seen the straw poll. They've seen the material now. And so during this period, we can engage with them, and we may have something to bring back in June for you to consider and adopt as a motion, or other board members may wish to make other motions as well. But I think given the gravity of the situation and the fact that the board has been deliberating for several hours on this, that it would be prudent and appropriate for the board to have an opportunity to consider this without taking a vote today. And if you're comfortable with that, Mr. Chairman, I would make that recommendation.
Yeah, Sunita and Eshvar, I find your arguments compelling. So is it okay with you guys if we table it until next month and do what Harvey just said?
Yes.
Yeah, I'm okay with that. Yes.
Yeah, no,
Sorry, Drew, I don't mean to
you-
make it harder, but I just want to do the right thing.
No, I think Sunita and Eshvar, you guys did exactly what you're supposed to do, and your arguments convinced me, and I'm the maker of the damn motion. So the maker of the motion will table the motion until the June board meeting. And then Harvey, you and Ms. Eaton May and Maytak will come back with a lot more for us to consider. And we also, I like, kind of what you're saying, Eshvar, we also get to hear the second case, and that's compelling to me too. Because I know there are some similarities or some differences. So does that all have to just say table it for a month, Harvey? Can I do that as the maker of the motion, Chairman?
You can do that as chair, not as maker of the motion.
Great. The maker of the motion agrees with the chair. Talking to myself. Let's go do that. All right, Ms.
Does
Emery,
the second agree with that?
Yeah, Dick, are you okay with tabling this till next
Yes,
month?
we're going in the right direction. Yes.
Drew, can I say something?
Oh yeah, jump in anytime.
Big thing. I think the bigger issue that beyond this case with Mr. Gallagher is the issue of disclosure at the time of filing the retirement applications. I think there has to be something that takes care of that because you'd hate to have more situations where so much time has elapsed between the discovery of a felony and the retirement. And so if there's a way, I don't know how this happens with the city or with the council, if there's some way of initiating some sort of movement to have that worked out, that way we in a position as the board don't have to deal with, hopefully, many cases like that going into the future.
Didn't you tell me, Maytak, when I talked to you a couple weeks ago, that Roberto and staff are working on putting that on the thing that gets signed? Or was that you, Roberto, told me? Are you working on that?
We were
It was
considering
probably
adding-
Maytag. I think it was
Yeah.
Maytag recommendation, but we're working on it to see if we can
Okay.
bring something to the retirement application process where they will agree to keep us apprised.
Congratulations, Howard. You get the Great Minds Think Alike prize for the day.
Well, yeah, because in FINRA, with SEC and FINRA, you
Yeah.
have regulations that people who work in the business have to disclose if they've been convicted of a felony and so forth and so on. And if not, they get kicked out of the industry.
That's correct.
Anyway, I thought it'd be a good idea, that
Yeah,
disclosure.
it sounds like it's in the works. Ms. Emery, court reporter, why don't you bop on off to
Oh,
lunch?
I'm sorry.
Mr.
Chair.
Lund.
Excuse me,
Dave-
Mr.
Dave
Chair.
Wilson.
Oh, yes.
Hey, Jack, jump in.
I'm sorry. Trustee Wilson has his hand up, Chair Alonso.
Jump in. I'm sorry, I'm blind here.
That's
Jump
right.
in.
There's 2 pages. That's all right. There's 2 pages of people on this meeting. So I was just going to let you guys know that the current outline that the POA has drafted does include a notification process. So if
great.
if all parties agree and the city adopts it, it will be in there.
That's great to hear. So great. So great. So you win the second Great Minds Think Alike prize for today. Maytag, are we free to let Ms. Emery go to lunch?
Yes, Madam Court Reporter, we will excuse you for the next 20 minutes for a lunch break. During that time, the board will continue with its matters. And once you return, we will take up item 3F for Kenneth Williams. Thank you.
Great.
And I will also be taking a break for those 20 minutes to get ready for.
Yeah. Yeah, if you need longer, take longer, Ms. Eaton. I think we got about another half an hour to hour business we can do.
Okay, thank you.
Sure. Okay. Prabhu, 3 hours later, you called for, are there any questions for the CIO? If not, back to you, Prabhu.
All right, thank you, Mr. Chairman. Private market spacing plan will be a breeze after all of this discussion, and it'll be the simplest thing you consider today. And so for that, and Dinesh has promised it will be 10 minutes. And over to you, Dinesh.
Thanks, Prabhu. So Sachin, go ahead and share the document. So we're going to present the private market spacing plan. As Prabhu mentioned at the outset of the meeting, this was discussed and approved by the investment committee last month. This is an annual process that we kick off after the asset allocations are approved by the board. And the objective is to model how we can reach and maintain the private markets asset allocation targets. The reason being that private funds are drawdown vehicles, and we as investors don't control the exact timing of when capital gets called in and out of different investments that we make. So a lot of assumptions go into producing the pacing plan. So we revisit it annually to recalibrate the models. And the plan is that I'll talk about what we've done over the past year, some changes in the market environment briefly, and I'll be followed by Sachin Sidana, who's a member of our private markets team, who I think you all haven't had a chance to meet. He joined us in October of last year, and he'll go through the actual pacing plan results using some of the output that was produced by our consultants, Makita and Neuberger Berman, who did all of the modeling for us, and we'll wrap up with our recommendation. So if we can move forward to slide 3. Okay, so it's been a busy year. We expect to make 20 investments over the current fiscal year, totaling $248 million. This is a much swifter pace than the previous fiscal year, where we did 11 investments for $97 million. The deployment so far has been mostly as expected. So the private markets program has matured to the point where we have a stable foundation of managers that we have invested with in the past or currently monitoring and continue to invest with as it makes sense. There's some cases where we look to scale those relationships, such as when a manager offers other strategies that are a fit for us or might be launching new ones that could be interesting as well. What's equally as important as the existing relationships that we have is keeping a strong bench so that we can potentially replace or supplement the existing managers that we have. So we spend a lot of time understanding the merits and considerations of other investments, even though we might not officially make an investment with those groups in the past. The next point is that now that we have diversified portfolios, there's different ways that we can add value. We went into it a little more detail at the IC, but for example, in real estate, by adding sector specialists that can add value instead of investing in diversified funds where managers may invest across different sectors. But if there's a sector such as the multifamily or industrial sector that we have conviction in, want to gain exposure to, it can make sense to invest in specialists that can add value within that sector. The last item is the informational advantage. This helps us keep as wide a funnel as we can to look at a lot of opportunities and get benefits in other ways, such as having off-list references that we can call upon when we're doing due diligence. Our current positioning is 18%, which is exactly what we anticipated in the previous pacing plan. We are about 7% underweight the private markets pacing plan target, and the main reason is the asset allocation change that was approved by the board in March. So you'll see that all of the 5 private asset classes were increased for target allocations. The market environment has changed, even the level of volatility that we've seen over the last 2 days. The things that are more specific to private markets are that valuations are elevated still, fundraising cycles have shortened, and funds are continuing to grow larger. So we'll show some charts over the next few pages that show some of these dynamics visually. Go to the next page. So here at the top, we show that valuations are rising and have been a contributor to the strong performance that we've seen. What's important to also note is that public markets have also had high valuations, and on a relative basis, private valuations are actually less overvalued than public investments. So if you look at the bottom of the page, this takes public over private, and when it's greater than 1, it means that public markets are relatively more expensive than private investments. So some of the areas that we highlighted to the IC was that we're being disciplined in this valuation environment, not taking on incremental risk to chase returns, and trying to be able to produce good results across different market environments. Moving to the next page on the compression of fundraising cycles. So a few factors at play here. So first being the strong performance that funds have seen. The upper left chart shows the performance of buyout investments over multiple vintage years in the dark blue bars, and it compares to the public markets equivalent. If those cash flows when private markets investors were calling capital or distributing capital were invested in public equities, how would they have done? And there's a wide margin of outperformance. There's also been a swift number of exits that have taken place. So managers that have made investments that have been successful, being able to liquidate those and continue to make new investments, as the upper right chart shows. And ultimately what this has led to is what's shown at the bottom of the page, is that the average number of years between the closings of different funds has shortened significantly. So what might have been 5 years between funds back in 2014 has become nearly 3 years in the current environment. For us, this means we need to be flexible about our investment pacing and acknowledge there might be years where we go above our pacing plan or below our pacing plan. So more so matching our investment pacing to the opportunity set of different investments, and not just that we have a certain set level of capital that we feel pressured to deploy. The next page shows where capital is being raised, and the highlight here is that the dark red bars are funds greater than $5 billion in value. And you'll see in the upper left that they have been taking the lion's share of capital raising over the last few years. In the upper right chart, they're also the group that has the largest amount of dry powder available. Dry powder being capital that's been raised and hasn't been invested into underlying investments yet. The bottom of the page chart shows that funds also continue to get larger over time. For us, what we've been focused on is groups that aren't so large that they're still able to take advantage of inefficiencies in the market and create value in different ways. So we've been spending a lot of time understanding the behaviors, the intentions of fund managers, and not so much relying on public markets, so that they need to rely on the IPO market for their exits because their assets are so large. And as an example, our buyout portfolio within private equity, about 60% is in mid-cap type of investment, so the smaller middle market end of the spectrum. With that, I'll pass it to Sachin to go through some more information.
Hey everyone, can you all hear me?
Yes.
Okay, awesome. So essentially, here is what we see, which is our pacing plan from our last year on the left-hand column relative to our actual deployments in each of the 5 different asset classes here. And so the main message here is that we've deployed greater than 100% or 100% of our pacing plan as we're allowed to do in our IPS in all of the 5 different asset classes over anywhere from 3 to 8 investments. So now here what we see is on the left hand, this table right here is our expected NAV at the end of this fiscal year, which is June 30th, 2022, based on our previous pacing plan versus our current estimates now. And so we see that there's a bit of a forecast error here, as we would expect. I'm going to quickly touch on some of these forecast errors. So for example, this current estimate of buyout, we believe we are lower in buyout at our year-end NAV, fiscal year-end NAV, relative to our previous estimate because of some secondary sales that we have made from our legacy buyout portfolio. For venture, we have had faster deployment of our investments in venture, so we are actually higher. We forecast venture to be higher than what we previously forecasted. For private debt, we have had quicker distribution, so our NAV is actually lower relative to our previous pacing plan. So now let's look at the table on the right over here, which shows our allocation by asset class from our previous pacing plan relative to our current estimates. And what we'll see here is that our previous pacing plan relative to our estimates are almost exactly in line. And then finally, we see our current estimates relative to our target, which we have the difference here. And that is mainly driven by our venture program as we work to build up our venture program, as well as our private debt and our real assets programs. And also, we'll note that because we had the increases in the allocations, that's also why we have a larger difference here. So this next slide is the actual plan level NAVs. And essentially, I'll first take a step back and say how we forecast NAV. So we'll essentially come out with the, we'll start with our beginning NAV, and we'll take into account actuarial assumptions, benefit payments and employer and employee contributions, as well as our expected rate of return for the plan. And so what we see here on this line is our previous NAV forecast relative to our, and this bolded line up here, our current NAV forecast. And so essentially the main takeaway here is that there's a very small difference, but there is some difference in future years. So for example, right here. And this difference is driven by the fact that we've had a very strong performance recently in this past fiscal year, and that leads to lower employer contributions to the plan in future years, which will thus reduce our NAV. So for example, we have a lower forecasted NAV here relative to our previously forecasted NAV. Right here, we just show our target weightings, which are our new updated weightings per asset class, and their corresponding NAVs as what we would expect by June 30th of this year. So this is a really cool chart here, and what this shows is high level, where we're showing how our actual exposure to the plan in terms of NAV trends toward our target exposures. So these dark bars over here will show our actual expected exposure on whatever date we're looking at. So let's take a look at this right here, for example. This 8.8% is showing that we expect our buyout portfolio to actually be at an 8.8% of our total plan on June 30th of 2031. And so the lightly colored regions in the background show our target. So essentially what we see is that we are approaching target for our various asset classes. So for example, for private real assets here, the gray bars, we continue to approach our target over time. And this will be driven by, for example, for venture and for private real assets, increased contributions to these asset classes as we build up our NAV, as we build up our programs, especially for venture. So essentially, net message here, we will be in line, we expect to be in line with our targets in all of our asset classes in the coming year. Now, finally, this is our liquidity requirements. Essentially, we're showing our flows for the private markets program. We expect to have a net distribution in 2023 with some net contributions as I've mentioned, work to build up our venture and our real assets programs. So we'll be contributing to these plans and to these asset classes, and then from these contributions, we will receive net distributions in 2028 and onward, and we see the cumulative cash flows here. So yeah, I'll pass it on to Dinesh now.
Okay, thanks, Sachin. So on this page, we have the actual recommendation with the dollar amounts associated with the data that was shown on the previous slides. And we're modeling out well into the future. So this is something that we plan to revisit annually, as I mentioned before. The highlighted amounts are what we're seeking approval for, which is a total of $334 million of commitments. And in addition to this, there's another item that goes hand in hand with this, which is the item 2C next. So I'll just preview what's to come on that if we can go to the next slide. So the IPS has limits for private markets on how much capital can be deployed for an asset class or a single strategy. And the table here shows that venture capital was originally excluded from this in the current IPS. This was an oversight that we wanted to make consistent with the other private asset classes and understand that there's years that we'll do more or less than the pacing plan. It's not intended to be a strict box of what we're forced to stick to. And like I said before, that there's clustering sometimes of good managers that we want to be investing with their fund strategies. And there's cases where we potentially want to do more. So venture was excluded from this, and now we're going to make a venture consistent with the other private asset classes. Important to note on the next page is that the venture approval process remains exactly the same. So the investment committee and board still retain the approval rights for all venture capital investments. If we go to the next page quickly. So that highlighted section shows, yes, the investment committee and board still maintain approval rights for that. So now we can go back to slide 13, see if there's any questions on the pacing plan, and perhaps to make it easier, do a separate motion for this item 2B for the pacing plan, followed by a motion for 2C, which we can show the specific attachment next.
Prabhu, how do you want to handle this?
As Dinesh suggested, Drew, if trustees have any questions, we are happy to take it. If not, if you can make a motion.
So floor is open, and it was so floor is open. If not, do you want to do 2C and then come back? Do you want to vote on this and then go to 2C as Dinesh said? What would you prefer to do?
I think we can vote on this, Drew, and then we can pick up the 2C motion.
Okay, great. So the floor is open to entertain a motion to approve the private markets pacing plan.
Okay, I'll move the motion.
I hear a motion by Ashfar and a second by Dick. Let's go around the room. Andrew.
Aye.
Sunita.
Aye.
Howard.
Yes.
Ashfar.
Aye.
Dick.
Yes.
Franco.
Aye.
Dave.
Aye.
I'm Chair Lyons. I vote aye as well. Back to you, Prabhu.
Thank you, Mr. Chairman. So 2C is exactly what Dinesh spoke about, was the tweak to the IPS language. And we are happy to take questions. If not, hopefully someone can make a motion on that.
Hey, Prabhu, quick question.
Yeah,
Is this the 150% of board limit? Is that what you're talking?
that's exactly right. Yes.
So is that, what does that mean from a practical standpoint? 150% stands out like a big number for variation.
Yeah, it is. And so we actually ran into this problem this year, right? As Dinesh said, sometimes funds raise capital in clusters, and that's got to do with the environment. And so we have some top tier firms that you all have approved, and several of them came to the market. And so we had to actually at some point say no to some of those because we did not have this approval. So with this, it actually gives us some flexibility. So the board and the IC, as Dinesh mentioned, still have the ability to say yes or no to these VC firms, and we'll still bring that list to the board. It just gives us flexibility. If they all come to the market at the same time, it allows us to invest with them. And there will be years when we are less than 100%, just depending on the fundraising cycle.
Yeah, and the principle I understand, but mechanically, I just want to understand. So is this 150% of each fund's limit, or is it?
150% of the cumulative pacing plan amount that is approved, not the funds limit. So we will still adhere to what the board has approved in terms of each fund.
Got it. So you can vary how much you invest every year. Basically.
That is correct. Yes.
Got it. Thanks. I'll do a motion if nobody else has questions.
No, that's great. Sunita moves to approve item 2C. Do I have a second?
Second by Santos.
Great. Second by Santos. Motion by Sunita. Around the room. Andrew.
Aye.
Sunita.
Aye.
Howard.
Yes.
Ashfar.
Aye.
Dick.
Yes.
Franco.
Aye.
And Dave.
Aye.
I'm Chair Lyons. I vote aye as well. Turn pages. That anything else, Prabhu?
That'll be all, Mr. Chairman. Thank you.
Okay, there is no old business. We
So
do
Chair
this.
Lanza?
Yes, go ahead.
Hi, is Council Eaton May on the line as well? Yes, I see her there. So, so I received a request from Council Eaton May with regards to the Kenneth Williams matter, agendized as item 4F. Mr. Williams will not be able to participate today. Our meeting went a little bit longer than the time certain notified on our agenda. And so I have a request from Ms. Eaton May to continue and defer item 4F so that the member and Ms. Eaton May can present at a later date, subject to meet and confer between council on the available date and availability.
Well, let's open the floor. Does anybody object to that? I don't. It's all your fault, Miss Eaton May. You ran us long. No, seriously. I think that's fine. That's fine, and that's actually a good opportunity for you to work with Harvey and Maytag, and that may bring some light to the Williams case too.
Okay.
Maytag, will you let the court reporter know then that we don't need her anymore?
Yes, I see the Madam Court Reporter on the line, and I'm not sure if she's present because she's muted and unseen, but I can email her to let her know that she's relieved for the rest of the day.
Great. It was a pleasure meeting you, Ms. Eaton May. Harvey and Maytack spoke very highly of you, and I can see why.
Oh, thank you. Thank you
We'll
very
see you
much.
next month.
All right, take care. Bye-bye.
All right. We don't have any old business. God, so Roberto unfortunately his mother passed away. He's not on the meeting anymore, and he and I made a little pocket bet that the meeting would go past 3. Unfortunately, I made the pocket bet that it would go past 3, and he made the pocket bet that it would be done by 3. So I'm gonna owe him dinner. Well, we can't owe dinner. We will split it. Harvey's sending me a text probably now. So we have our update. Pam, I didn't see Pam online. Pam, are you there? No. So in the absence of Roberto, who's driving 4C? Is it you, Barbara, or you, Prabhu?
No, it's me, Benji.
Benji, go ahead. You drive for a while, Benji. 4C.
Okay, so these are the 4 new contribution rates resolutions for police tier 1 and tier 2 and fire tier 1 and tier 2 that we present to you on an annual basis. They are based on the latest actuarial valuation prepared by Chiron. And as you can see in the cover memo, the changes from last year to this year are not that significant, with tier 1 increasing slightly and tier 2 decreasing slightly. So after the board approves the resolutions, we will start working on sending the letters to the members to inform them of the new contribution rates. It's pretty straightforward, but I am happy to take any questions.
Thanks, Benji. Floor's open. Any questions? It's really just a formality. Any questions? If not, I will move that we approve sending these out. Is there a second?
Second, Gardner.
Great. Motion by Lanza, second by Gardner on item 4C. Let's go around the room. Andrew, how do you vote?
Aye.
Sunita.
Aye.
Howard.
Yes.
Eshvar.
Aye.
Dick.
Yes.
Franco.
Aye.
Dave.
Aye.
I'm Chair Lanza. I vote aye as well. Good job, Benji. Who's covering 4D?
That is me, Chair Lanza, Barbara, Deputy Director.
Great. All yours, Barbara. Take it away.
So good afternoon. This memo is requesting approval to negotiate and execute a third amendment to the agreement with Marty Boyer, the Communications Advantage, to extend the term of the agreement through June 30th, 2023, with no additional budget being requested at this time. The services provided by Ms. Boyer are related to the board's strategic communication plan, and the board adopted that plan in May 2020. And the communication plan includes such things as, the newsletter, social media posts and blogs, and educational video scripts, etc. And per the board's policy, the CEO is authorized to enter contracts up to a value of 50,000. Any contract above this amount requires board approval, and board approval is required for any contract that would result in a cumulative contract value with a single vendor above 50,000, which is the case for this vendor. So staff are requesting approval to negotiate and execute a third amendment to the agreement with Marty Boyer Communications Advantage to extend the term of the agreement through June 30th, 2023.
Great. Thanks, Barbara. It's going well, right?
It is going well so far, yes.
I mean, I think everybody's been pretty happy overall. Any questions for Barbara? If not, I will entertain a motion to approve this.
Motion to approve.
Do I have a second? I'll second. Lanza will second. Motion by Santos, second by Lanza. Let's go around the room. Andrew.
Aye.
Sunita.
Aye.
Howard.
Yes.
Eshvar.
Aye.
Dick.
Yes.
Franco.
Aye.
Dave.
Aye.
I'm Chair Lanza. I vote aye as well. That was item 4D. we took item 4E, the Gallagher matter at the top of our meeting. So 4F is already 4E is already done. We just heard that 4F is being delayed to June. We ran over, so Williams had to go somewhere else.
Yes, and Madam Court Reporter, I just sent you an email. We are deferring this matter and you're relieved for the day. Thank you.
Thank you so much, everybody. I appreciate it.
Thank you. You did a great job. We really appreciate you being with us today.
Thank you so much. Bye.
Okay, Maytech, we're on to the factual findings for AB 361. My agenda says you go first and then I go.
As you guys are aware here, thank you, Trustee Lanza. Based on the governor's proclamation for the state of emergency due to the COVID-19 pandemic, there is a current ongoing state of emergency, and the city council for the city of San Jose continues to recommend social distancing in city facilities. Based on those two factual findings, based on the materials provided to you, this board, if adopted, those two factual findings may continue to meet virtually under AB 361's abbreviated teleconferencing procedures. Thank you.
So quick question, Maytech. I know you've been sort of looking in your crystal ball and expecting some word to come down from Sacramento, but no word yet, huh?
No word yet, though everyone's eyes are on the governor's office. It is anticipated that the governor may take action in the next few days or weeks.
You said that 2 months ago, Maytech.
I know, but
yeah, all good. All right, based on the information presented by council and provided with our board backup materials, it appears the following factual findings justify the continuation of virtual meetings under AB 361. One, as Maytech said, the governor's proclamation of state of emergency continues due to the ongoing pandemic. And two, San Jose Council's recent resolution continues to impose or recommend measures to promote social distancing in city facilities. I cannot read faster than this. Do I have a motion to adopt these two factual findings for the election to use the AB 361's abbreviated teleconferencing procedure for the next 30 days for this board? Do I have a motion?
So move, Santos.
I got a motion by Santos. Do I have a second?
Gardner, second.
I got a motion by Santos, second by Gardner. Let's go around. Andrew.
Aye.
Sunita.
Aye.
Howard.
Yes.
Ashvar.
Aye.
Dick.
Yes.
Franco.
Aye.
Dave.
Aye.
I'm Chair Lanza, and I vote aye as well. Don't forget, at the end of the meeting, we'll have to do the committees too. So stick around at the end. All right.
Hey, Drew, this is Howard.
Jump in, Howard.
If I had a question, one question to go back to the case of Gallagher in general, if I can ask one question, is this the right time?
What do you think, Maytech?
no, I do not believe that this is the right time. Counsel for Mr. Gallagher is not present. So I would reserve your question for when the matter comes back before the board at the June meeting.
The question is just about the actual the San Jose Municipal Charter, whatever it is, 13.36 something. If it's just about that and nothing to do about him in specific, can I ask that question?
I would counsel that we would reserve that question so that Ms. Eaton may, to the extent she has any responses to whatever I say in response to your question, has the equal opportunity to respond.
Oh, okay.
Yeah, sorry, Howard, Maytech has cautioned me again and again. This case has fingerprints all over it that might trigger an appeal, so we want to be squeaky clean.
All right, got it.
Yep.
Thanks.
Okay. Announcing the service retirements of Jorge Gutierrez, Police Lieutenant, Police Department, effective May 15, 2022, with 27.73 years of service. Good for you, Jorge. Anson G. Kahaku, Police Officer, Police Department, effective May 15, 2022, with 25.69 years of service, and Manuel Rodriguez, Police Officer, Police Department, effective May 16th, 2022, with 26.61 years service. Motion to approve.
So moved.
Motion by.
I have a motion by Dave, a second by Santos. Let's go around the room. Andrew.
Aye.
Sunita. Sunita.
Sorry, I was just fumbling. Yeah,
That's
aye.
fine. Howard.
Yes.
Ishvar.
Aye.
Dick.
Yes.
Franco.
Aye.
And Dave.
Aye.
You guys want to say anything about any of these guys?
Yeah, this is Dave. I've worked with all three of them, and Anson Kaku and I started the police department. We're in the same academy 25 years ago. They're all great, outstanding cops, and I wish them the best in their future retirement.
Great. We've only got one deferred vest. I should have read along the other ones. Deferred vested Julio C. Morales, police officer, police department, effective May 31st, 2022, with 22.32 years of service. A lot of twos in there. I will move to approve. Is there a second?
Second.
Motion by Lanza, second by Santos. Andrew.
Aye.
Anita.
Aye.
Howard.
Yes.
Eshvar.
Aye.
Dick.
Yes.
Franco.
Aye.
Dave.
Aye.
Any comments on Mr. Morales? I thought we wish him the very best in retirement. Now we will read off those of our members who have passed on since our last meeting. We'll have a moment of silence. Notification of the death of Kenneth J. Garino, police officer, retired March 3rd, 1981, died March 27th, 2022. Good, nice retirement. Survivorship benefits to Ann P. Garino's spouse. Notification of the death of Virgilio Hernandez, firefighter, retired August 21st, 2007, died March 17th, 2022. Survivorship benefits to Veronica Hernandez, spouse. A notification of the death of David Mosley, fire captain, retired August 3rd, 1995, died March 25th, 2022. Survivorship benefits to Ginger Mosley, spouse. Notification of the death of Donna Tonry, police officer, retired July 28, 2008, died Feb 7, 2022. Survivorship benefits to Stephen Culverwell, spouse. And notification of the death of Orville Yarbrough, police officer, retired Feb 2091, died December 12, 2021. Survivorship benefits to Mary Yarbrough's spouse. We've left a lot of spouses behind. Let's have a moment of silence. Thank you. Any of you guys want to say anything about these folks?
Let police go first, please.
Just
Go,
my
Dave.
condolences to their families.
Yeah, this is Dick Santos. Virgil Hernandez was a good friend, good crew member. I worked with Dave Mosley, the best of their families. Thank you.
Thanks, Dick. All right, now we're going to go through the committees. Investment committee, Eshvar.
Yeah, so I guess we have the minutes from the February of both the Joint Committee and the Police and Fire IC Committee. And we also had a meeting last month during which we discussed the private market pacing plan, which we discussed here today, and also discussion of a public market equity presentation by Christina.
Thanks, Eshvar. I'll note for the record, we're receiving and filing the minutes as this first set of Feb 22 joint and IC and the minutes from March 3rd. Audit risk, Sunita.
We haven't really had a meeting except about the AB. I always forget the number, the guidelines for meeting remotely. So nothing to report.
That's great. So we received and filed the minutes from that brief meeting on March 3rd. Governance, Franco.
Yeah, I'll call to order the governance committee meeting.
No, not yet. Not you. Jump the gun, Franco.
Oh, sorry. Yeah, I don't think we added anything.
No. You're done. You're right. You're like Sunita. I will note for the record we received the minutes of the 2-minute meeting on March 3rd to extend AB 361. Disability, Dick.
We continue going on. I see we're canceled. So with that, we have the oral update on this on the chair. That's me, committee, the minutes. Other than that, looking forward to the next one.
That's great. Dick's the same as Nito and Franco. We receive and file the minutes for the abbreviated meeting on March 3rd. There is action on the JPC. I forget. Eshfar, are you chair of the JPC? I forgot.
I'm the vice chair.
Yeah.
Yeah.
Do you want to do it, Andrew or Eshfar?
Yeah, well, go ahead if you want.
No, Andrew, go ahead. Andrew, go ahead.
Go ahead, Andrew.
Yeah, we haven't had a regular meeting since March 4th, but 7.5B is an item that we discussed at our last full board meeting in April. But the only thing that we forgot to do was to vote on it. So that's why this is back on the agenda. We need to take action on it for approval. This was just the CEO performance process feedback. It's the same thing that we did with the CIO the previous month. Just made a few changes, red line changes, and we're going to practice that this coming up July when we do the evaluation process.
Yeah. In fact, I met with the chair of Federated, Spencer Horowitz, and as Andrew says, we're ready to kick off this new process. So we've got to approve this. I'll move that we approve the new process. Is there a second?
Second, Santos.
Great. Motion by Lanza, second by Santos. Let's go around. Andrew.
Aye.
Sunita.
Aye.
Howard.
Yes.
Eshfar.
Aye.
Dick.
Yes.
Franco.
Aye.
Dave.
Aye.
I'm Chair Lanza. I vote aye as well. We are almost done, but don't leave. I gotta think about this for a minute. Hey, Linda, can they switch tapes earlier, or do they have to wait till 1 o'clock to switch?
You have to wait until 1 o'clock.
All right. So we may squeeze in one AB 361. We'll have to take a 1 minute break right on the hour. Are there any proposed agenda items for next meeting? If not, we're adjourned. Over to you, Maytech.
Yes, thank you. If staff could